Now, we need to open an assessment. Here's the top, but if you still have.
Okay, Commonwealth versus Christopher Caraway. Commonwealth versus Christopher Caraway. Are you Christopher Caraway? Good morning. You're here on 24 CR 0093. Were you born in 1984? What are the last four digits of your social security number?
1014.
Here for pretrial conference. What do we have?
Come to a resolution on this one.
Mr. Stockton, will you come around?
Yes.
What is charge you choosing?
Correct, the methamphetamine, 20 grams of meth would be a vote first. So I'm ready for trial date, that's what he wants.
What did you offer?
10 years. We got some left, we got price.
Is that a C?
Yes.
C to go to a B?
If it goes to be a vote first, if he's convicted, it's a value felon. 2050 might.
Your Honor, maybe we could have one more free trial conference before that would be acceptable.
I mean, that's the reason I looked at you. I just want to make sure you know what you're doing, you know. Sometimes in life, the choices you make, none of them are real good, you know. So.
Oh, we need to verify the line.
Okay.
If you could just call him back. Oh, something here, a few minutes.
Haley Harbor.
Yeah.
Haley Harbor.
Hey.
Commonwealth versus Haley Harbor, 22 CR 0039 and 24 CR 0089. You are Haley Harbor, born in 2000.
Yes.
Last four digits, social security number 6213.
Yes.
What do you have, Mr. Stockton?
This case, Ms. Harbor was 5-year sentence, pre-trial verdict for 5 years. She is supposed to be doing home incarceration, part of the plea. Probation control allowed her to go to Indiana and do home incarceration there. Because her parents' vehicle ended up in Tennessee, violated her home incarceration. And that commission put it down.
Now, which one of these cases is that? Will you all move to the left and let Mr. Stockton get so we don't have you on camera, Mr. Stockton.
Be 22-31.
Okay, and now where are we at on 24 CR 0089?
Well, if we don't reach a resolution, I guess we have to use trial. That's the basis of the education.
Are you gonna like roll them both into one? Is that what you do?
I hadn't said on a pre-trial conference about anything. She wants to go to rehab. And she wants to take additional time and maybe get an option, but if not.
I don't. I just think you probably need to set a trial date. You know, the problem is if you get somebody to get them out and they take the car and go to another state without permission, there's not much indication that she's going to be compliant with anything. If that's true.
Your Honor, I know excuse for absconding, but I think she had children that she was visiting in Tennessee. Pressing, I don't know, again, I'm not sure if that makes a difference, I wanted to let the court know that she was in Tennessee visiting her children.
That's probably true, but she was supposed to get on home incarceration in Indiana. You know, you're not with your children if you're in prison.
Well, do you want to have one more conference day on this? You want to set it for trial? What about the diversion revocation? We can go ahead and do that now. You want to have witnesses here?
You can do that.
You want a hearing or you going to stipulate?
We'll stipulate.
Okay, well, I will revoke a pretrial diversion and order precinct's investigation report to be done by probation and parole and have her sentencing on March the 6th.
You would have got a pre-trial negotiation on February 28th at 9, and we try to wrap it up.
February 28th, and maybe I can wrap this up and let them know. James McInich. James McInich. James McInich. This is 24R0090. Are you James McInich?
Yes, all right.
Good morning. Were you born in 1962?
I was
Last 4 digits, social security number 3474.
3474, that is correct.
Okay, what do you have, Mr.? You moved to the left a little bit. What do you have, Mr. Stockton? What do you have?
We have, in this case, we all have been trial, we have probably got it settled, and we're pretty close, but I need to contact the victim's family one more time. So if we can have them fill the March 6th and the pre-trial conference, pre-trial negotiation.
When is the pretrial negotiation?
February 28th.
February 28th at 9 and March 6th, the next court date. We either settle it then or set a trial date. What is the charge that you?
It's a one in danger.
Yeah. Does it have a weapon or something in it or what?
Mr. McInich alleged with a pointed weapon at a delivery person from the junction station. It's proof of only Mr. McInich and that person.
Does he have any, what kind of bond does he have?
There's a $2,000.
Okay, what's his history?
It's okay as well as the CA is already.
Tell me something like that. Does he have any like violent past or anything?
I don't know.
I'm on the hospital.
I don't know, we've pulled the NCIC report. We may have that statement.
In 2005, we had.
Speak up.
I'm sorry, in 2005, we had an assault conduct degree in domestic violence charge. Everything else.
What are the other things?
AI.
Where do you, if you have a bond, where would you be living, sir?
Well, assuming I still have my camper and the private operated address on my documentation.
Was it a neighbor or something?
No, the victim in this case, he's working at the junction station delivering food. Mr. McInich called in order, and we taking the student. That's what happened. Allegedly. And we've got 2 witnesses. McInich got 2. But I don't know why anybody would make that.
Well, for strange reasons, I don't know. Do you have any, since it's gonna be, well, how long has Mr. McInich been in?
Which is some, so I can get it in that.
Well, Do you have somebody can make a bond for you that has any property or anything?
I can't answer that.
Okay.
I have to say no.
Okay, well, let me see if I can get a $25,000 surety bond instead of 10,000 cash. Somebody comes to the clerk's office and prove that, and then I'll put you, if you can get out on that situation, I'll put you under a curfew. Stay at your residence there, except you go to church, work, or the doctor, maybe the grocery store, so you aren't gobbling around and just stay away. So I'll change somebody, I'll give them there. It's not a big bond. Okay, it gives you at least some chance to get out for these next days. The 28th for negotiation and March 6th for the next court date.
Thank you.
Yeah,
That's.
yeah. Colton Randolph. Colton Randolph. Y'all ever seen that 9%? I've got so much German. Combo versus Colton Randolph, 24 CR 0087. Are you Colton Randolph?
Yes, Your Honor.
You born in 2006. Last four digits, social security number 4446.
Yes, Your Honor.
You're on pretrial conference. What do you have, Mr. Stockton?
Well, the case here in Clinton County, I was asking Mr. Rutherford, is it state prison yet, non-probation, license, and this instance, evidently it's not. It's gonna take me some time to get all the records on this.
What's the charge?
It's assault first degree where he was in one endangerment where he was going down the road, he got out here at the community college and the highway, and victim was on the skyline, and all kinds of records.
Yeah. So you're not ready for a negotiation?
Maybe next month we'll set it right.
Okay, well, have you had a negotiation date yet?
We've had it, actually, but
Were you there at the negotiation date?
Yes, Your Honor. We were trying to work something out with Pulaski County because there are also charges involving the same incident.
the beginning of last weekend, the fleet when they, somehow he made it all the way to Clinton County, didn't start.
Yeah.
That's what we read.
Well, you want to see if, is that the officer involved there? You're not involved in that? Maybe, why don't you, check Pulaski County and see if they're willing to transfer their portion of the case since it's one continuous chase. See if it transferred down here, we can handle it since the majority of the damage was done down here. Not
Another way
at-
on, I see.
That's right.
Yeah.
Thank you so much. Okay, we'll be back here on March 6th.
Thank you, Your Honor.
Yeah, and between now and then, sir, they're gonna see your attorney and the Commonwealth are gonna see if they pull all of it down here in Clinton County, so you can take care of all of it at once. Was there anything else about Christopher Caraway?
Yeah, we've got the lab, we're ready for trial, that's what we want.
Okay, come on up here.
Yeah, she's got it, we want to see.
Caraway, right? Yeah. Okay, you think this could be a 1 day or a 2 day? You've got all the tests, you got everything you need.
Will you still check on the things if they're available there? Yeah, we'll have to follow that and get available, but we can do that.
How about March the 11th?
That's fine with me. March 11th.
We possibly do it another day.
Well, we could possibly do another day. Do you have any reason why we should do
Well,
it on that day?
My firm has a jury trial.
Do what?
My firm has another jury trial on that day.
You're gonna be experiencing that in front of it.
But I understand if that's what the board needs us to do.
It'd be good for you to go solo. We can't go much worse than the
Going
last,
solo tomorrow.
can't go much worse than the last two, Colin.
Yeah, I don't
They
think-
can't blame you with those two, you know. Let's do it on March the 11th.
You got one of them. These people, I'm thinking this day, these cities.
Thank you, Your Honor.
Yeah.
She don't know the lab.
Okay. Now we're out of custody here. William Burmell Jr. says they're active warrant out.
Yeah, we'll put him in CIC.
He's out of state, he's in North Carolina.
Is he in jail there?
Yes.
Okay.
Did you hear that, Mr.
We did.
Christopher Connor? Commonwealth versus Christopher Connor, 25 CR 0005. Are you Christopher? No, excuse me. 006. Mr. Connor, were you born in 1982?
Yep.
Last four digits, social security number 5347. You have an attorney.
No,
Why don't you have an attorney?
the people in town here will take it, but all the ones, I don't have the money to give them $5,000 or $10,000.
Well, I'll let you sign an affidavit. I don't know whether you're gonna be eligible for a public defender or not. But we'll let you do an affidavit over here. Fill out a form here. Yeah, Virginia, Connor, you wanna come on up here too? Well, I'm gonna ask public advocacy to stand in for the purpose of arraignment only, I think. Are you Virginia Connor? Were you born in 1983? Last four. 82, 83. 83. The last four digits, social security number 3171. You're here on 25 CR 005. Mr. Connor, there's your indictment. Counselor, do you acknowledge the identity of Mr. Connor received indictment? Waive formal reading and arraignments, enter plea not guilty, reserving for him all pretrial motions.
Yes, Your Honor.
Okay. You can hand him the indictment if you want to. This is Ms. Connor. The grand jury of Clinton County has returned an indictment charging you with theft on office, taking this position. And burglary in second degree. You understand those charges? Counselor, you acknowledge the identity of Ms. Connor, the received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Yeah. And these are reciprocal discovery orders. When you have an attorney named or you get an attorney, they'll provide the discovery and this help you get ready for your defense. Y'all can go with this lady here and fill out some forms to see if you're eligible for the public defender. If you're not, you can make the decision whether you want to incur the cost to counsel or try to represent yourself. But I'm telling you, it's a good investment to have a lawyer. And when you get charged with something like this, okay? So you go back and fill these affidavits out and then y'all can come back. Billy Cranfield. Don't hear your response to Billy Granville. Check and see if he was served.
This is the pre-trial conference.
Who represents?
I do, Your Honor.
Are you gonna say anything?
I'm sorry, I haven't spoken with him.
Hello?
I apologize. I'm trying to reach out to him now to see.
Well, I'll tell you where you can find me. In the Clinton County Jail, because I'm issued a bench warrant for failure to appear.
Yes, Your Honor.
Okay, Isaiah Garman. Commonwealth versus Isaiah Garman, 24 CR 0080. Are you Isaiah Garman? You born in 2001.
Yes, sir.
Last four digits of social security number 1566. Mr. Poindexter, you represent Mr. Garman. This is a pre-trial conference. Y'all have anything to announce?
This is a case where the victim came into our office.
Y'all will move to the left a little bit.
This is the case where the victim came into our office. He had text messages on his phone between himself and Mr. Carmen. Let him, when we let the kid go, open my thing, right, either legal or accident. So we're trying to get those records to search them or agree order. And we've not got the response.
What was the charge?
It's theft of possession. So if we have one more pre-trial conference, see if I can get those records.
Okay, you come back here on March the 6th.
You know, let's say for February 28th, so Mr. Poindexter and I really not had a chance to talk about it since we don't have the record.
Negotiation day, February the 28th, and then your next court appearance is March the 6th. Both of them are conditions for your bond, okay?
And both are not anyone.
9 a.m. here. You're gonna do them here, are you?
Yes.
Okay, here.
Thank you.
Brian Gross. Commonwealth versus Brian Gross, 24 CR 0041 and 24 CR 0058. You are Brian Gross, born in 1985. The last four digits, social security number 2218.
Yes.
What do we have, Mr. Stout?
I'm a victim from the case with Mr. Gross and Mr. Lyons that was shot. It's in the Wayne County jail. Been there for some time. I need to meet with him before I had decided whether to try this case or not. And I was going to ask the court if I could do a transportation order for Larry, Craig, I'm bringing him down to the courthouse so I can meet.
On the 28th or before?
Before that, I was in her transportation.
That'll be good.
Yeah, I really don't go.
I don't know anybody over there that wants to go to the Wayne County Jail. Mr. Groves surely doesn't want to go to the Great Wayne County Jail. do you?
But I need to meet with him.
I understand. Okay, just submit a transportation order. And we'll set this for the 28th and the 6th.
Yeah, I'll meet with him before.
Well,
Yeah, I'll know an answer for the 28th.
28th and 6th, both of them are conditions your bond, 9 a.m. here. 28th for negotiations, 6 your next court date, unless otherwise notified, okay?
And that's the same for Mr. Lyons.
Mr. Likens, is Mr. Likens here?
Yes, Your Honor. Certain thing I'll get.
Have I got to get him up here? Get a picture of him. You're Michael Likens, is that correct? We're on 24 CR 0074, 24 CR 008. As you just heard, they're gonna go interview the victim. And then you're to be back here on February the 26th for negotiations, in March the 6th for your next court date. Both of them are conditions of your bond, and the Commonwealth attorney will be hold your lawyer before them, okay?
As it's filed, I'll be out on the 28th, but this is our custom practice. I'll be meeting with Mr. Stockton prior to the 28th. Sorry.
Well, you need to give a day certain, because your client has to be there.
I'm also be here.
Well, I didn't say you had to pick the 28th. I said we need a date certain. Let's pick another date.
That's fine.
Hey, get away from Mr. Stockton here while this is going on. You distract him.
I'm so sorry.
Mr. Stockton,
Yes, Your
Mr. Cross, as happens, it's not going to be available on the 28th. Do you have a date certain that you can meet with him to make sure his client has a right to be there too? The whole purpose of these conferences is to have the defendant and the lawyer there so they can communicate with each other. So defeats the purpose if you meet on the side.
I mean, well, the 26th, I think. Or we can make, we can come up here and we can negotiation day at 9 AM on the 25th.
No, I've got a meeting. Okay, let's do it. Let's do the points text about, we can do it, or do it 1 o'clock, then it's fine.
26th at 1 o'clock. And then the next court date,
Come by my office, about 15 minutes.
the 26th at 1 o'clock here. And then March the 6th, be back here too. Okay, both of them are conditions of your bond. You need to write those down for me, Mr. Cross, okay?
26.
Yeah. Ryan Nally says active warrant, Mr. Stockton.
Yeah, we'll put him in CS.
Stephanie Prater, active warrant.
Same.
Thank you.
Yeah, Emily Savage. Emily Savage. She's been served, I guess this
I'd ask
was,
for a warrant of arrest, then, because
and she's been served.
I didn't know what kind of bond she had.
Back was 20 years. He's given us 6 days from the jury.
Giving them wrong court date.
She under a bond?
Well, she's supposed to be here on March the 6th. So I can't really do
Well,
that.
this is, the reason I'm concerned is this is the issue, the victim allegedly she'd already destroyed her car, and she got making her brags about that she's gonna get her when this is over with. So I'm just concerned about this late court date. I don't know why it's selling on the 6th.
I don't either.
Yeah, that's a big question. Who said this?
Who's what did what you say?
The day after they did the bond, they did March 6th,
When was she arrested?
January 22nd.
That's just inexcusable.
Bond decision was over like, February 6th.
What was the bond decision?
He can have maturity, pre-trial, require curfew, no contact with victims and all in the favor conditions.
Okay, she violated any of those terms?
Yeah. She
Allegedly.
has all the following.
Okay, that's what I'm telling you.
Yeah.
I mean, we don't have to wait till the next rule.
If I have
date.
adequate proof, I'll file.
Yeah, and we don't have to wait till the next rule date here.
Okay.
She hasn't been arraigned, this,
No, that's the reason.
so the thing about it is, we can do a special arraignment for you. You can still find the bond violation, whether she's been arraigned or
I
not.
understand.
Okay. Sharon Sidwell. Commonwealth versus Sharon Sidwell, 24 CR 0054. Are you Sharon Sidwell? You were born in 1970.
Yeah.
Last 4 digits, social security number 7041. We're here for a pretrial conference. What do we have, Mr. Stark?
We just got a lab report on this case, and I don't think Mr. Rutherford ever met this lady because Mr. Green, okay, so we're gonna negotiate.
Okay, February the 28th, is that right?
Yes, sir.
And then March the 6th. Be here on February the 28th and March the 6th, both at 9 AM. The conditions your bond, Ms. Sidwell, you understand that?
Okay.
Scotty Spear, said he's in rehab, but he's not. Somebody in rehab transport you. Commonwealth versus Scotty Spear, 24 CR 0088. Are you Scotty Spear? Born in 1994. Last 4 digits, social security number 9202. Represented by Mr. Cross. What do you have, Mr. Stockton?
Well, I, go to the court,
Y'all move over this way a bit.
we need one more pre-trial conference, and Mr. Cross is not going to follow through the lay I am, because I'm not contacted with him saying that because I was tired. You're busy.
The 28th will be a negotiation day, 28th of February. Next court date will be March 6th. Both of them conditions you bond.
Your Honor, let's just do that, the 26th at 1 o'clock, which provides.
Okay, 26th at 1 o'clock is negotiation day, and your next court appearance is March the 6th. Both of them conditions you bond. Wesley Stockton. Wesley Stockton. Are you Wesley Stockton? This is 24 CR 0086. Mr. Stockton, were you born in 1984? The last four digits, social security number 484085. You have an attorney. You go to district court, to district, this is a direct submission. When you made your bond, did you file an affidavit for a public defender? We'll get him an affidavit. She's still back there with those other two folks. Just get on the front row. For the purpose of arraignment, though, I'll let the public advocacy sit in on it. You have a right to remain silent. This gentleman's just gonna stand in today for the arraignment. Then we'll determine whether you're entitled to public defender or not. I'll tell you that before you leave here. Don't leave here without talking to me about that. The grand jury of Clinton County has charged you with torture of a dog or cat. You understand what the charge is? Sign a reciprocal discovery order. When you get an attorney, they'll share information with them. So you wait there and we'll have her to affidavit to see if you're entitled to that. You acknowledge receipt of indictment, identity.
Yes, Your Honor.
Yeah. Waive formal any arraignment and plead not guilty, right?
Yes, Your Honor.
Stop. Say that. What's your heart?
Shelter. Okay, let's go off the record. Yeah, you'll tell me if that's the other fellow. Mr. Stockton, you need to come and let her fill an affidavit out for you too. Need to take a look at these. You know, have to find out where you. The Connors come back around, go ahead, please. Ma'am, both of y'all raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but the truth. You have $3,000 a month below your hand. You have what is your $3,000 a month income come from?
He works, I don't have a job, yeah.
Well, you have,
I did have a job that was let go when somebody sitting around and trying to take care of everything else.
I mean, you have on here that you have income of $3,000. That's why I was asking you that.
Well, she put that on there, but she said, well, we were still married, and he said, not for mine.
Okay. Now, where were you employed previously?
I worked for American Force, it says, I got a stipend, they sit on the shop and they look at me on leave until.
And where do you work?
Is that? Well, you broke your.
Is that construction? Where y'all working? Yeah.
You wrote it down.
No, y'all got a lot of work left to do on that.
Couple more years.
How much?
Couple more years.
Yeah. Well, I'm gonna go ahead and appoint a lawyer, but I'm going to assess a fee for $1,500. That'll be for both. I said, I'm gonna go ahead and appoint a lawyer for you, but I'm gonna assess a fee of $1,500. That'll cover both of you, okay? And it appears to me that this lawyer here will have to interview to see if y'all can use the same lawyer or not. You know, I don't want you to say anything, but it could be that y'all will have different defenses so that we have a conflict. You understand what I'm saying? So he'll interview you today and you be here for negotiation. Both of you be here for negotiation on the 28th day of February and back here on March the 6th. So the first day will be a negotiation day between y'all, your lawyer and the Commonwealth. And so y'all know what they have and what the options are and that sort of thing. And then you'll come back here on March 6th to see what's going on, okay? So I'll go ahead and fill the order out and make it $1,500. And then you need to pay the $1,500 by the by the 28th if you can, okay? Well, you just leave it at the clerk's office. Okay? Okay, thank you. Well, no, you need to ask your attorney. Okay, thank you. Okay, let's go off the record now. I guess maybe they did an interview with Mr. Cope. Mr. Stockton, did you do with Mr. Stockton? Is he eligible? Yeah, I'm gonna appoint public advocate for Mr. Stockton. So Mr. Stockton, this is your lawyer here. You'll be back here on February the 28th with him for negotiations, and then your next court date is March the 6th, okay? He's gonna write them down. And you need to meet with him beforehand and talk to him about your case. Now we're on in about 12 minutes with Marion County and then Russell County. They don't, neither one of them are on there right now, I don't think. So let's go off the record.
Hold up. I don't know that.
Are they coming?
Yeah, go back down.
Who is it?
14, 13. Is this right? Go ahead. I see you back. 38, 33.
You're on the list to see the doctor. You're on the list to see the doctor.
Once y'all find Mr. Stock. Let's go ahead to the Wayne County Jail. Russell, will you turn your camera off until we call you, be next, okay? Commonwealth of Kentucky versus Joshua Evans. For sentencing, it's 24 TR 0036. Are you Joshua Evans?
Yeah, exactly.
You born in 1988?
Yeah, 1988.
The last four digits, social security number 0079.
Yes.
Have you had an opportunity, you're here for sentencing, have you had the opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah, I think so.
Have you gone over it with him?
Yes, sir.
Okay. Is it substantially correct?
Yes, sir.
Is there any reason this gentleman should not be sentenced today?
No.
It appears that Mr. Evans received a total of 3 years. I'm a little confused on exactly.
Yeah. I'll just take that to you out.
How much you have since it's got one case. Okay. It can be full. Yeah. Okay. It just didn't have the date it was revoked and they usually does that. Okay, I got you. On January 9th, 2025, your pretrial diversion was voided. You had a sentence for 3 years and a misdemeanor trespass of 12 months, and they're running concurrent. We'll sign a judgment. Your attorney will come over and tell you when you might be eligible for shock probation or other probation, okay?
Okay.
Thank you very much. Do we have anything else in Wayne County? Okay, Wayne County, you can be excused. Thank you very much.
Thank you.
Now, let's go to Russell County. Russell County, are you on the line?
Yes, Your Honor, we are.
Okay, I have Christy Clooney on the, you're the probation officer, is that correct?
Yeah.
Okay.
Yes,
Commonwealth versus Parker Bird. Commonwealth versus Parker Bird in Russell County.
1 second, Your Honor. They didn't have Parker on our list. I'll grab him for you.
Okay, well, let's go ahead and have people that you have while we're doing that, okay? You have Lindsay Cash there.
No, Your Honor. They didn't have her on our list either. I'll grab her as well.
Justin Daly.
I have to get Mr. Daly and Mr. Pearson out last, separate from everyone else due to their nature of their charges, Your Honor.
Okay, well, let me go over who we got there to make sure we're on the same page, and then you bring me who you want to, okay?
Alrighty.
Okay, Parker Bird, Lindsay Cash, Justin Daly, Charles Dickin, Chiquisha Dickin, Christopher Pierce, Candace Tweedy, and Dale Perales.
All right, I have everyone except for Daly, Morales, Parker, and Cash up here right now.
Just bring me somebody up here, anybody.
Let me start with Chris Pierce, Your Honor.
Are you Christopher Pierce?
Yes.
We're on 23 CR 0038. Mr.
Yep.
Pierce, was born in 1981.
Yes.
Are the last four digits of your social security number 9875?
Yeah.
Here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Okay, is it substantial, correct, counsel?
Yes, Your Honor.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On January 9th, 2025, the pretrial diversion in your case, sir, was voided. Therefore, you are sentenced to 2 years and continue to be required to follow what the social service clinicians do. You can get out anytime sooner for that, okay?
Okay.
Okay, thank you very much.
That's it.
Okay, give me somebody else here, Russell County.
What are you giving?
Candace Tweedy.
Candace Tweedy. Commonwealth Kentucky versus Candace Tweedy. 23 CR 0058. Are you Candace Tweedy? Are you Candace Tweedy?
Yes, Your Honor.
You born in 1997.
Yes, Your Honor.
Last four digits, social security number 2464.
Yes, Your Honor.
It's up for a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, she had a 3-year sentence on possession of controlled substance first. After a probation violation, she was placed in a specialty court and she was terminated from the specialty court when she was stopped.
You gonna stipulate?
Yes, Your Honor.
Okay, they stipulate on behalf of Miss Tweedy. We'll order a pre-sentence investigation report to be done. Should be sentenced
Over
on
there.
March the 6th. Okay. Okay, there'll be the probation parole officer come over there and interview Miss Tweedy. And see what we can do as far as getting in compliance, okay?
Okay, thank you, Your Honor.
Thank you. Okay, give me somebody else, one, Jerry.
Alrighty. Mr. Dickin. As soon as I get.
What's your name, sir?
Charles Dickin.
Commonwealth versus Charles Dickin, 24 CR 0043 and 24 CR 0044. Mr. Dickin, were you born in 1961?
Correct.
Last four digits, social security number 5978.
Yes.
What do you have?
Motion to revoke probation.
What do you have, Mr. Hunman?
I think Mr. Rutherford and Mr. Johnson worked this out,
Yes, Your
but
Honor.
I'm not exactly sure.
Tell me about it.
I believe Mr. Dickens has about 10 years on his they agreed that if he pleads to DUI, that he can then be assessed for drug court. And if accepted, then he'll be probated with drug.
I don't have the DUI case here, do I?
No, it's not a conviction.
So is it down in district court?
It is, we have the officer here.
Well, the thing about it is, what we can do is let him go ahead and enter a plea downstairs, but you need to have, in my opinion, a written offer to him. If you give him a written offer, that includes him pleading guilty on that. And that way, if something happens, he can withdraw his plea if it's part of negotiated.
Well, it's not a plea, it's a revocation.
You what?
It's a revocation, it's not a plea.
This is a revocation.
You said if he pled guilty to DUI is what you told me. That's what I'm talking about. Is he pleading guilty?
Can't do it here.
Well, that's right. That's the reason I'm wanting a plea agreement with that in it. And then once, I'm not gonna give him anything until he goes through and does the plea. I mean, I'm not gonna cut him a break here and then him back up on the DUI.
I don't argue with that.
Okay? So y'all just reach some kind of agreement on what you're gonna do. And we'll set him back up here on the March 6th. Yeah. And let's put him on negotiation for the 28th to make sure all this is happening. So go ahead and get a written plea offer. Okay, Mr. Hennon? Okay, thank you very much. The officer can be excused now.
Yes.
Thank you.
Thank you.
Okay, give me, what's your name, ma'am?
Keisha Dickens.
Chiquita Dickey. Chiquita, I wish you had an easier name to say. I have a hard time saying your name.
It's Keisha for short, Your Honor.
That's what, you care if I call you that, or if we develop such a relationship? I can call you Keisha, then. So, okay. You're here for sentencing in 24 CR 0075 and 24 CR 0052. Miss Keisha Dickens, were you born in 1979?
Yes, Your Honor.
Last four digits of your social security number.
3253.
Okay, have you had an opportunity to look at pre-sentence investigation report done on probation parole?
Yes, Your Honor.
Is it substantially correct?
Yes, Your Honor.
Any reason this lady should not be sentenced today?
No.
The Commonwealth recommends that the sentence in 24 CR 0052, 24 CR 0075 shall run concurrently for a total of 5 years. Probated for 5 years. The defendant agrees to reside in Ohio. If she shall return to Clinton County or to Kentucky, she must enroll in the Clinton County Specialty Court, better known as the drug court. Okay, now can probation and parole, but when you have.
If she can be at my office in the morning at 8 o'clock, I will work on her transfer. She said that she wouldn't have a place to stay here until her transfer is accepted by Ohio.
Okay, well, I'm gonna let her out in the morning at 7 o'clock. Get out in the morning, 7 o'clock, and go straight to probation parole office, okay?
Keisha, as soon as you get released in the morning, you need to come straight to my office. If you're not there,
Okay.
I'll have to inform.
That's fine, as soon as I'm released, but you're gonna be an hour ahead of me, Carson, so,
If he arrested you at 7, that's fine.
okay? I'll be there, directly as soon as I leave here. And does that take care of the failure to appear as well? Corey?
What, yes, everything's taken care of.
Okay, now with court costs on this? $150, and I'll allow you to pay that at $30 a month. The first payment will be due 30 days after you're released tomorrow, okay?
Yes, Your Honor.
And you can pay that over the phone, correct?
I don't care how she pays it, as long as she pays it, they'll take eggs, and they about 2 dozen eggs now, so. Okay. Okay,
Thank
well,
you,
good
Your
luck
Honor.
to you. Good luck to you. Now, I see Marion County over there. I want to flip over since there's just one case in Marion County and do the Marion County case real quick. Commonwealth, Kentucky versus Johnny Duval. Are you Johnny Duval?
Yes, sir.
You born in 1970?
Yes, sir.
That's 4 digits, social security number 2803. You have a motion for shock probation. Tell me about it.
Well, Your Honor,
Well, your attorney's here. Wait
excuse
just-
me?
Wait a second, your attorney's here. Say something so you activate the mic. I can see that.
Judge, It's been 119 days since Mr. Duval's sentencing and 76 days prior credit for that for 195 days since his total incarceration at this time. It's a drug case, Judge, and all of his conduct, everything that was related to his, as a result of his addiction. At this time now, Mr. Duval has been, since he moved to Marion County, was I believe enrolled in the SAT program and he's involved in that. As well as, he's sober and with, being incarcerated for
Is he
over.
in Marion County just as a state prisoner, or did he have charges up there too?
No, he's a SAT prisoner.
Stockton, come around and tell me what you think about this.
Your Honor, this is a case where Mr. Duval had 140 grams of methamphetamine, a handgun. He did the 5 years at the time I posed probation or shot probation.
Yeah, with a handgun involved in it, I'm not gonna get shot. Okay,
Very well.
okay, thank you very much.
Thank you, Judge.
Thank you, Marion County, for participating.
Thank you.
Yeah, let's go back to, I guess to Russell County. I guess, Dale Morales, is that right?
That's Parker, now,
Oh, Parker Bird. Yeah, Parker Bird. Commonwealth versus Parker Bird, 24 CR 0077. Are you Parker Bird?
Yes, sir.
Born in 1997.
Yes, sir.
Last 4 digits social security number 0903. What do you have, Mr. Stockton? Mr. Stockton, what do you have?
Thank you, Your Honor. Mr. Bird is a coded dispatch. I also have signed waivers too. We had already talked about them, but I wanted to include the sign.
Okay, just another part of this. Mr. Byrd, a motion has been tendered. It says you wish to enter a guilty plea today. Is that correct?
Yeah,
Are you currently under the influence of drugs or alcohol?
no,
Is this plea freely and voluntarily given?
do what?
Is this plea freely and voluntarily given? You doing this voluntarily?
Yes,
Okay, are you the same person? Named in indictment 24 CR 00077.
yes,
Is your judgment impaired today?
no,
Have you had plenty of time to review your case and talk to your attorney, and are you satisfied with her advice?
yes,
You don't have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You got the right not to testify against yourself. No one can make you say anything. Right to speak, probably. Jury, right to be represented. Y'all need to quit talking up there. You're keying the microphones. Okay? Thank you. You have the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and process issue, bail or attendance. You have a right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea, you give up all the rights. You understand that?
yes, sir.
Now may consider the Commonwealth's recommendation, but I may apply any penalties provided by law. I don't have to accept it. I don't accept the recommendations and decide to impose a harsher sentence. You have a right to withdraw your plea. You understand that? Now I'm going to ask you a few qualifying questions. Have you previously been diverted in the last 5 years?
No,
Have you had any felonies in the last 10 years?
no,
Are you currently on probation?
no,
You understand if you complete the diversion program, the charges will be dismissed with pre-trial diverted. Then you can get your record expunged. You understand that?
yes, sir.
You understand if you don't successfully complete the program, you'll be brought back in front of me, and if I revoke the pre-trial diversion, you'll have a pre-sentence investigation report and get convicted felon that you'll use against you in the future. You understand that?
Yes, sir.
What's the Commonwealth's recommendation?
Mr. Bird plead guilty to possession, unlawful transaction with a minor second degree. Receive a sentence of 5 years, pre-trial verdict, 5 years supervised. He'll be referred to the SSC, follow all recommendations, have no contact with the victim or the victim's immediate family, receive credit for time served, he will be released upon the entry of this plea, obtain and maintain gainful employment or do community service. And all evidence in this case will be destroyed. You also pay full cost of discretion in court.
Is that what you agreed to?
Yes.
What are the court costs?
155.
I'll give you some time to pay that. Pay it at $30 a month, first payment, 30 days from today. You know, are you pleading guilty because you did commit the act charge and the indictment is amended? Is that right?
Yeah.
Okay. And knowing your constitutional rights and explain to you still your desire to proceed and enter a plea and charge and allow the court to fix your sentence.
Yes.
Is that your signature on there, sir?
Yes.
I'll accept the agreement, sign it. You don't need to meet with probation and parole, is that correct?
Yes. Parker, I need you to be at, probation and parole in Monticello tomorrow morning at 8 a.m.
Okay.
If you fail, I have to collect your DNA. If you fail to report, I will have to get a warrant for you.
Okay.
So make sure you're there in the morning at 8 a.m.
Okay.
An hour won't be long enough for me to get over there, let it out at 7.
Your Honor, we had, if the court would, in the plea, it was we thought that he could be released today.
Well, I really don't like to release anybody until I have,
Release him at 7 a.m. and if he's a few minutes after 8, within a reasonable.
somebody could pick you up at 7 a.m. and bring you right over to the probation and parole office in Monticello.
If Monticello.
Okay? So have somebody there to let you off in the morning at 7. Yeah, you got a question?
Yeah, so I'm not getting out today?
No, we can't get you in to see the probation and parole officer. I'll let you out first thing in the morning. Okay?
Yeah.
Okay.
Ms. Cash?
Lindsay Cash. Are you Lindsay Cash?
Yes.
We're in 24 CR 0078. Were you born in 2003, Miss Cash?
Yes.
Last 4 digits social security number 1501. We're here for a free trial conference. What's the Commonwealth have to say?
Pre-trial diversion, you know.
And we also have that waiver that was previously discussed but signed for Ms. Cash. She was a co-defendant.
Okay. A motion has been tendered that says you wish to enter guilty plea today. Is that correct?
Yes.
Are you currently on too much drugs or alcohol?
No, Your Honor.
Is this freely and voluntarily given?
Yes.
Are you the same person named in indictment number 24 CR 0078?
Yes, sir.
Is your judgment impaired today in any way? Is your
Sorry?
judgment impaired today in any way? You know what's going on? You're
Yes.
not messed up, right? Have you discussed these charges with your attorney and are you satisfied with their advice?
Yes.
Do you believe you're fully informed about your case?
Yes.
You understand that you do not have to guilty plea today. You have certain rights under Kentucky. The United States Constitution. I'm gonna read those rights and at the end, I'm gonna ask you if you understand them, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to be heard, cross-examined, all witnesses called to testify against you. right to produce evidence, right to call witness in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Do you understand that by entering guilty plea today, you give up those rights? Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I decided to sentence you to something harsher, you have a right to withdraw your plea. Now, I'm gonna ask you a few qualifying questions. Have you previously been diverted in the last 5 years?
No.
Do you have any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand if you fully complete the program of pretrial diversion, the charges will be dismissed and you can have your record expunged. You understand
Yes.
that?
Yes.
You understand if you do not successfully complete the program or there are glitches in it, you be brought back before me for a hearing and I can revoke your pretrial diversion and sentence you as a felon. You understand that?
Yes.
You understand that if were to happen, you'd be a convicted felon that could enhance penalties in the future under persistent felony offender law. You understand that?
Yes.
What is the Commonwealth's recommendations?
Your Honor, Ms. Cash, plead guilty to unlawful transaction with minor second degree. See the sentence of 5 years, pretrial diversion for 5 years supervised. She'll be referred to the SSC for evaluation and follow all recommendations. She'll have no contact with the victim or immediate family. She'll receive credit for time served, will be released upon complete. She'll obtain gainful employment or do 30 hours community service a week and pay court costs discretion.
What was the transaction in the matter?
This is the case where the allegedly when they gave this child methamphetamine. And we're talking about teenage. That's the allegation.
Now, are you pleading guilty because you committed the acts charged in the indictment as amended?
I'm sorry.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yeah.
Are you doing so of your own free will?
Yes.
Knowing your constitutional rights, I've explained to you, it's still your desire to proceed with your plea and allow the court to fix your punishment. Is that correct?
Yes.
Can I see the plea agreement? Is this your signature on there?
Yes.
Okay. I'll accept the agreement, sign the diversion order. What time can she meet with probation?
Same time in the morning. I need you to be at the Wayne County Probation and Parole Office in the morning at 8 a.m. Judge had you released at 7. Just come straight there. If you're a few minutes late, that's fine. But if you're not there,
Well, she's got a time difference.
that's fine. That's fine. I'll adjust for that.
Okay,
You need to be there within a reasonable amount of time to drive from the time you're released to the time you get to the jail, to my office in Monticello, it needs to be a reasonable amount of time. It don't need to be 4 hours. It needs to be drive time.
okay, and what is the court cost?
$155.
Okay, it's $155 court cost. I'm gonna give you some time to pay that. First payment is not due for 30 days. That'd be $30 and $30 every month. You get that paid off, okay?
Okay.
Okay, thank you very much. Good luck.
Thank you.
Your Honor, we have Mr. Daly and Mr. Morales here for you. Whichever one you want to see first.
Okay, I guess, we probably need to see Mr. Daly first.
All right.
Just Daly. Are you Justin Daly?
Yes, Your Honor.
You born in 1989?
Yes, Your Honor.
The last 4 digits, social security number 6037.
Yes, Your Honor.
You're here for the purpose of arraignment today. I have reviewed, your report. It says you haven't been, raise your right hand, please. Swear the testimony you're about to give is the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
It says here that you have, y'all are key in the mic, okay? It says here that you haven't worked for 2 or 3 years. What's the deal?
I just been on drugs and stuff, Your Honor, just to be honest with you. I ain't got no reason to lie to you.
Can't be too much more honest with that. I'm going to go ahead and appoint you to public advocate. And you're here for arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with 2 counts of incest, persistent felony offender concerning incest twice, rape in the first degree, 2 counts, persistent felony offender in the first degree on the rapes twice, and assault 4th degree. You understand those charges?
Yes, Your Honor.
Okay. Counsel, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, interplead not guilty, resorting all pretrial motions.
Yes, Your Honor.
Okay, Mr. Stockton, is there forensic evidence? Come up here just a second before we get you on camera. Please, is there any forensic evidence or anything? So you want to have a negotiation date
Yeah, we can go ahead.
on the 28th of this month at the next court appearance?
Okay,
Will be on March 6th, okay?
Okay, thank you, Your Honor.
Your attorney's been appointed and he'll be over there to see you pretty soon.
Okay, thank you.
Thank you, seat right there, Justin, Mr. Prowse.
Okay, is that, I guess we have Dale Corrales, is that correct?
Yes, Your Honor.
Are you Dale Corrales?
Yes, sir.
We're on 24 CR 0094. I've looked at your affidavit as far as public defender. It appears that you qualify, make sure. You're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with rape in a first degree vulnerable victim, sexual abuse first degree vulnerable victim, sexual abuse first degree vulnerable victim. I'm not asking whether you did this or not. I'm just asking if you understand the charge.
Yes, sir.
Okay. I'm going to sign a pre-trial discovery order. It's your attorney will be given information to help you prepare for your defense. You're going to be over here on the 28th of this month for a negotiation day, and then March the 6th for your next court date. Both of them are conditioned to your bond. And after your attorney comes over there and talks to you, he'll fill you in on the rest of the process, okay?
Yes, sir.
Okay, thank you very much.
Thank you, sir. Thank you, sir.
You didn't plead not guilty.
Yes.
You did on his behalf. You acknowledges that you're sitting indictment. Waive a warrant reading arraignment, interplead not guilty, you're serving all pretrial motions. Okay,
Yes.
okay, thank you. Now, does that finish us out with Russell County? Do y'all have anybody else over there that works for us?
Ready then?
Are you finished, Russell?
That was all we had, Your Honor, unless you all have anybody else.
Well, I know I can take some of Clinton counties if you want them, but I guess you got all you want.
Sometimes.
Okay, thank you very much.
All right, you have a good one, Your Honor.
Thank you. Yeah, let's go to the Clinton County Jail. Clinton County Jail, Gary Boer, sentence. Commonwealth of Kentucky versus Gary Boer, 25 CR 0001. Good morning, Mr. Boer.
Sir.
I said, good morning.
Good morning, sir.
Were you born in 1978?
Yes, sir.
Okay, Clayton County, there's something wrong with your volume down there.
Is that better?
Okay, you're here for the purpose of sentencing. The Commonwealth have anything to say about this?
Yes, Your Honor.
You want to come up here?
Yes. He had this is a rocket case, we gave it a felony plea. And then prior to him being sentenced, he got new charges, theft of a credit card, theft of unlawful taking disposition, infant theft, unlawful taking disposition, all in district court. So I don't know if the court wants to proceed with sentencing or not.
What was the sentence
It
imposed?
was 2 years probation.
Okay, what I'm gonna do is I'm, at least temporarily, I'm gonna reject the plea agreement. And then we'll take a review of it, okay?
That'll be back.
It is,
Probably I'll say it for negotiation.
negotiation date on the 28th and the next court date for, March 6th. Your attorney will be down there to talk to you, Mr. Brewer, okay? You got some more charges, and then we're gonna try to wrap them all up into one for you, okay?
I'll see you today, Mr.
Knock it
Burke.
out somehow with the.
Okay, thank you.
Thank you.
Archie Boykins. There's something wrong with this. Clinton County, will y'all check your volume down there?
Yes,
The
we
other
will.
jails have been good. Well, it's a good sign somebody out ahead trying to get it there. That'd be asking too much. Y'all say something, let me hear, see if I can hear you now.
Can you hear us better now?
Oh, it's better now, yeah.
Okay, you'll just have to go without the speaker. Okay.
Okay. Commonwealth of Kentucky versus Archie Boykins. Are you Archie Boykins?
Yes, sir.
You born in 1976.
Yes, sir.
Last four digits, social security 8005.
Sir.
You're on 24 CR 0064 probation revocation. Plus Commonwealth have to move you to their counselor.
Mr. Boykin had a 10-year sentence probated. He had to serve 120 days home incarceration. He'd already served 100 days in jail. While he's on home incarceration, he went over with Weston McGall and was moving furniture. Mr. Boykin said he was doing it, get transportation, but the landowners where he was moving the stuff didn't have permission. I talked to Ms. Costello. My recommendation is he just do 120 days in custody rather than home incarceration. It's not fouled up, rather than revoking. But the court must have a hearing, we can have a hearing. That's not a vote now. We'll just send them.
So he was doing what now?
My understanding was he was with Wesley McGall, who was a convicted felon. He shouldn't have been around. He couldn't associate with him. He went over to the neighbor's house. Mr. Boykin thinks he was still in range on his home incarceration law, is his story. Didn't leave. He went over there, helped him move some furniture. So they got him for trespass because he wasn't supposed to be over there. He didn't have landowner permission. He was with a convicted felon.
Were they stealing the furniture?
Well, that hadn't been determined.
No.
I don't know, Mr. Shelton, he's here, he's the officer on it. But if you want to pass it to next month, I can have Mr. Book out here on the home incarceration, or we can do the 120-day sanction. It's kind of more relevant.
Let's do like a 30-day sanction, and we still got something to hold.
We got 10 years over his head. He owed me 120 days on home incarceration. You got about 30 of it in before.
Oh, okay.
And
See
then,
what you're saying.
so I.
So you just let him finish it out.
Finish out the 120.
Okay, we're not gonna revoke you then, Mr. Boykin. We'll just let you serve the remainder of the 120 days out
Thank you.
in jail.
Started January the 2nd, so we'll get 120 days from January 2nd.
Okay. And then he'll be probated without any more.
He's already on probation.
He'll be probated for the rest of it
Yeah.
without anything. Okay.
All right, thank you.
Okay, thank you.
I'm free to go now.
Yeah, well, no, you're not free to go, but you go
Well,
back
I
and
know
sit. Good try though, Mr. Boykin.
All right, thank you.
Mitchell Finley.
Mitchell. You.
Commonwealth versus Mitchell Finley. I'm gonna sign the order. of
Your Honor, I'm sorry, I didn't addition. I got a call this morning from, family over Mitchell's in custody, and he wants me to represent him.
Well, he filled out a request for a public defender, right?
Perhaps he did, but I believe,
Are you retained now?
yes, been, it says I'm hired.
You're
All right,
hired.
Mitchell, is that all right with you? Hello?
Mitchell, David Cross is here. It says that one of your family members has hired him to represent you. You want David Cross or you want a public defender?
Yeah, that'd be fine.
David Cross. Which, you want David Cross?
Yeah, that'd be fine.
It'll be good. You're here for the purpose of arraignment, Mr. Finley. You have the right to remain silent. Were you born in 1966, Mr. Finley?
Yes,
The last four digits of your social security number is 0720. 0720. Are the last four digits of your social security
yeah.
number
yes.
0720?
Sorry, y'all.
Okay, you have a right to remain silent. The grand jury of Clinton County has charged you with strangulation, menacing, and unlawful imprisonment in second degree, 2 counts. It appears to be. Mr. Cross, you acknowledge the identity of your client, receive indictment, plea formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Okay, we'll set a negotiation date on the 28th, and the next court date will be on March the 6th.
For us, Lord, we're available the 28th.
Yeah, 26.
Yeah, I'm sorry,
Your Honor,
26th.
Dennis had talked to me about Mitchell previous, and I'm somewhat familiar with him. I think he's been in jail a while, and we've got a lot of issues, medical. What is his bond?
It's $10,000 cash and he comes property.
You want to talk about bond, let's carry it.
Well, I'm not inclined to lower it. That's a reasonable bond, no allegations.
Pretty cheap.
Steve,
What?
the victim was called Steve about this affair.
I had.
Okay, well, that's not.
I got more information.
Yeah, well.
Okay, let's go. Thank you very much. Mr.
Mitchell,
Cross will be down there to see you, okay? Mr. Cross will be down there to see you. Ferdinand Gerger.
Bond reduction.
He's trying to, that's what you just did.
That's what he asked for. I'm not what they done.
Ferdinand Gerger. Are you Ferdinand Gerger?
Yes, I am.
This is 23 CR 0063 for sentencing. Mr. Gerger, you born in 1958.
Yes,
Last four digits of your social security number are 5474.
yes.
Have you had an opportunity to review your pre-sentence investigation report done by probation and parole?
No, I haven't.
Yes, it has, Your Honor. I went over it with
Okay.
you yesterday on the laptop, do you remember?
Yeah, the gentleman that's standing there told me about it.
I don't know, if you saw the full report.
Was it up on the laptop when he was going over it with you?
Yeah,
Okay, did you see anything on there that was incorrect?
no.
Okay, counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Your pretrial diversion was voided on January the 9th, 2025. Therefore, we said we'll impose the sentence of 3 years. And your attorney will come down and explain to you your options as far as shock probation that you can ask for at a later date. Okay, thank you very much.
As far as what? now?
Shock probation. He'll tell you when you're eligible to file a motion for shock probation.
Okay, okay, thank
We
you.
gotta explain that to you. Thank you very much.
Yep.
Yeah.
So what
Jamie Harold. Arraignment. Jamie. Jamie Harold. I'm signing a order appointing Jamie Harold a public advocate. Mr. Harold, I'm gonna have to take a little short restroom break. I'll be right with you, okay?
Yeah.
Well, what are the order?
I don't know that response. Yeah, we got. Oh, we're out. You don't have to problem. It's a long time. Okay, you did see. Yeah.
Okay, Mr. Harold, you're here today for the purpose of arraignment in 24 CR 0081. You have a right to remain silent. I've assigned a public defender for you. Were you born in 1977, sir?
Yes, sir.
Last four digits, social security number 3525.
Yes, sir.
You have a right to remain silent here. The grand jury of Clinton County has returned an indictment charging you possession of a handgun by convicted felon, being a persistent felon offender, unlawful possession or taking of a firearm, PFO on that charge. Do you understand what those charges are?
Yes, sir.
Okay, Counselor, you acknowledge the identity. Client received indictment, will waive formal reading and arraignment, enter a not guilty plea on his behalf, reserving all pretrial motions, scheduling a negotiation day for the 28th, is that right? And the next court appearance for March the 6th. Was there extradition done in this case?
He was being held in Tennessee until I guess they finished with him. We got him up here. So.
Okay, so your attorney will be down to talk to you very soon, okay?
Yes, sir. Miss Williams.
Yeah, okay, thank you.
I'll see you soon.
Bobby Hicks. Bobby Hicks.
Bobby.
Calm down, Fergie.
Commonwealth versus Bobby Hicks, 23 CR 0017. Are you Bobby Hicks?
Yes, you
Were you born in 1966?
Yes.
Last four digits, social security number 7813.
Yes.
Okay, you're here on a probation revocation charge. It was a Commonwealth.
Now, Mr. Hicks has a 5-year sentence on one done in the first degree. He's had 3 positive methamphetamine tests since June of last year. I'd ask him to be assessed with special order to stand voting.
Mr. Hicks, the Commonwealth, I don't know whether you heard or not, suggests that drug court or specialty court might be a help to you instead of sending you to the penitentiary. Would you agree to be evaluated by them to see if you're eligible for drug court?
Yes.
Okay, well, I'll go ahead and sign the referral. It'll be a little while. They'll get down there and do you, and then I have to vote you in next month, do an orientation, and then we might get you out and see if we can't help you with this addiction problem. You got it, okay?
Okay, thank you.
Okay, thank you very much.
You too.
Nathaniel Johnson.
Go ahead. Thank you, Tom.
Commonwealth versus Nathaniel Johnson. Are you Nathaniel Johnson?
Yes, sir.
Good morning.
Morning, how are you?
Today for your arraignment on 25 CR 002. Do you have an attorney?
No, I do not.
Okay, it looks like you signed one of these affidavits and you are eligible to receive the services of a public defender. So I'm going to appoint you a public defender right now. He's standing here and hear it. You acknowledge the identity of Mr. Johnson?
Yes, Your Honor.
Okay, the grand jury of Clinton County has returned an indictment charging Mr. Johnson with burglary in the second degree, theft by lawful taking or disposition, and being a persistent felony offender on the burglary charge. You understand those charges, Mr. Johnson?
Yes, sir.
Yeah, I'm gonna sign a reciprocal discovery order where the Commonwealth have to give you, y'all are key in the microphone. You're key in the microphone. Your attorney will be back down to see you. Have a pre-trial negotiation day on the 28th, and your court date is on March 6th, okay?
All righty. Thank you, Judge.
Yes,
I appreciate it.
Jeremy Kempton. Commonwealth versus Jeremy Kempton.
Your Honor, we entered our here for me.
This is 23 CR 00030 Commonwealth County versus Jeremy Kempton. You are Jeremy Kempton.
Yes, sir.
You born in 1981.
Yes.
Last four digits, social security number 2874.
Yes.
Here, what does the Commonwealth have to say?
It's our motion to revoke, Your Honor.
Tell me about it.
Mr. Kempton began probationary period and he was convicted in 2023 and was sentenced to 5 years on the charge of assault of an officer. He was probated by this court on November 24th, 2024. Yeah, 24. Dr. Jay, there's 24, you may be about 643.
Sir, probation.
That's what was he said, incorporated to this court. That's going to do the probation, Your Honor, on December 26th, 2024. He had a dirty test for amphetamine.
You speak up just a little bit.
A dirty test for methamphetamine. That was his first serious violation in January this year. Is that correct?
Yes, sir.
He admitted to a second dirty drug test, methamphetamine. He is now in charge of district court on a charge that has been completed harassing communication of a sexual nature with an next girl.
And is that it?
I think quote.
Okay, Mr. Cross.
Your Honor, I was contacted by Crowley Stars yesterday, Mr. Kempton's employer. I'm very familiar with Mr. Stars. Mr. Kempton's been in his employ for some time. I note that the nature of concrete platform and boardwalk.
Just let's get down. I'm sure he's a great worker and he's indispensable and stuff.
Well,
what do you want to do on this?
The point I was going to make is that in December and January, from people I had to get in trouble because it's too cold to work. Now, we acknowledge use of methamphetamine twice. We want to report it to whoever he was.
You want to have a hearing on it, is what you're telling us? Okay.
Yes, it's quite colorful about the,
Yeah.
about photographs.
You had any problems with him besides this?
But you use of that, he
Class.
asked me
Class.
twice, use of that. He transferred back to the Wayne County office. He changed the address probably in October, November, even supervised officer.
What's the underlying charge?
Assault in the 3rd degree.
Police officer.
Yeah.
Was that a jailer or what was it?
It was an arresting officer. Obviously, I'm not familiar with this place.
I don't know, because I didn't have it.
So he sent some dirty photos to an ex-girlfriend. What is he allegedly, what is he alleged to
His
have done?
testimony will be that his ex-girlfriend.
No, I just want to know what he sent.
He's charged with harassing communications, having received multiple text message over a period of time, and it includes this one in January and December. That includes sexually explicit images of the defendant's private part as well as proposition.
And he says she asked him to send those.
Well, I don't want to get into that. You know, you get an opportunity to present it.
I don't want to believe, Judge, that he just doesn't have a lot of regard to law. He got it right. Broke it.
Well, let's have a hearing on it since they don't stipulate to it. So schedule a hearing. You just got rid of it.
I'm ready. Just because he's missing work, we'd like to do it as soon as possible.
Well, do you have your witness here? You have any witnesses here?
I think Mr. Kempton would be the only witness.
Do you have the proposed victim here as a witness?
Yes, Ms. Thompson, you're out.
Okay, we'll call her as a witness, I guess. Okay, you want to call Mr. Morrow first, the probation officer?
I think I will. I thought I was dealing with Mr. Payne, John, but,
Mr. Morrow, you raise your right hand, please. Testimony about to give the truth, the whole truth, nothing but the truth. Is that correct?
Correct, Your Honor.
Okay, go ahead, Mr.
Mr. Morrow, what is your occupation?
Employed with the Department of Corrections, Division of Probation and Parole.
And has Mr. Jeremy Kempton been in your line of work as supervisor?
Yes, I've supervised him since he transferred to Wayne County in October of 2024.
And what is, tell the court, beginning with the latest, if he has had any significant violations of his parole?
While on supervision, he's had use of alcohol, failure to report contact with law enforcement, failure to report change in home address. And in December, more recent stuff, this was a use of methamphetamine. And then in January of this year, he had another use of methamphetamine along with the new misdemeanor charge for harassing communications.
All right, and what is your recommendation as to this?
Well, let him tell me about the harassing communications. Give me some facts about it.
What are you know about the harassing communication charge?
The only facts I have is from the criminal complaint as well. I spoke to the alleged victim in this. She was telling me about the different communications they had. That time,
She's here to testify.
Okay.
Your answer, Mr. Cross.
Mr. Cross, you like to inquire?
Mr. Morrow, when you first undertook supervision of Mr. Kempton, was he working?
I believe so, yes, I've got it here.
And was that for Troy Starnes?
TK&B Construction.
Okay, good construction work. That's fine. That's fine. And I see on the 26th of December, he tested positive, he initially denied it, and then acknowledged he used. Is that correct?
That is correct.
And then he met with the SC and was going to complete the ILP. Is that correct?
Let's see what he was referred to. Yes, he was referred to ILP through CBI in Albany.
And then he came in on January 5th and acknowledged he used again on January 5th. Is that correct, sir?
He came in December 9th. I think I may have a typo in my date there.
Okay. Was there one use of meth or two? I guess that's the question.
There's two uses of meth. He did come in as directed. I called him, and he admitted to using on January the 5th.
Okay. So he probably came in on January the 9th, not December 9th.
Correct. Yeah, typo on my part.
Okay. All right. Now, otherwise, has he been cooperative and respectful with you?
He has. I don't have a long history with Mr. Kempton, as I've just had him since October.
Okay. No further questions.
Are you, officer, are you familiar with his overall criminal record?
Just for what he's on supervision for.
Know what's happened in the last 10 or 15 years?
No, I am not. No.
All right. So,
Nothing further, Mr. Morrow.
You call your next witness,
Ms. Thompson.
Ms. Thompson, what's her first name?
George.
George, you want to come up here? You raise your right hand. You swear or affirm that the testimony you're about to give is true, no truth, nothing but the truth. With some water help, you think?
Yeah, I've been sick. It's just tongue sores.
Okay.
You need to leave.
Okay.
Where do you live, Mrs. Thompson?
I live in Schooner's Landing in Albany, Kentucky. Yes.
And how long have you known this been in there?
Probably close to 8 years.
Okay, you need to lean down on the
Sorry.
microphone. How long have you known him?
Probably close to 8 years.
What kind of relationship did you have with him during that?
It was pretty good at first, but then it was up and down and
You all have never been married.
no.
You recently filed a complaint against him alleging that between December 10th of 2024 and January 7th of this year, that he sent you a lot of harassing communication. How was that done?
Over text messages and he posted stuff on Facebook. I mean, it's just been on and on.
Now, were you all a couple when that started?
Before Christmas. That was before Christmas.
I'm talking to her.
Sorry.
I'm having a real hard time hearing Your Honor. I don't know what we can do.
You can come on up here and get closer. You know.
Yeah, sorry.
When did they start?
You can move up here, Mr. Cross, closer to it.
It's your audibility, Your Honor. It's not the law.
Go ahead.
Okay. I know that was before.
Okay,
It was before
you know how to
Christmas.
go to the back of your voice and talk back there?
Barely,
Do what?
barely. I mean, it's just.
Try to do that.
Okay.
Can you tell the court the nature of the communication that you received from Mr. Kemp?
Well, I mean, he just kept on with sending his girlfriend's pictures, you know, I don't wanna see that stuff.
His present girlfriend
Yeah.
picture. Do you?
Yes, I don't need to see that. You know, calling me names and all this and that, you know. We're grown people. We don't need to be doing that.
Did he send you, explicit images of himself
Yes,
and of his girl?
yes.
What, did he ask you to do anything, make any kind of provocation?
Yeah. He was wanting me to come up for Christmas and have sex, and I can't do that. He's got a woman that's where he needs to stay.
Do you have these pictures saved on your phone?
Yes,
Have they been taken off with photographic form or are they?
No. It's all on my phone. It's all on my text messages. I've not deleted anything. Yes.
You have those text, you pull those text messages.
Yes. I don't need to say that.
I understand, I've had some of that myself. Tell me when you're ready.
Okay, yeah, I turn my phone back on.
Let's start with the first series of text messages that he sent you relating to what you just talked about.
Okay,
And the other day.
I'll just let you read them if that's okay. Would that be okay if you read them?
You have voicemails too, or just text?
No, just a text message.
Well, I'd probably let somebody else read them maybe because we can't understand. Can those be transferred some way, Brendan? Can she copy those? She could photocopy.
Could we lay her phone under the thing and put them on the screen?
I don't know whether you can or not. That's what I'm asking.
I don't know.
You talking about putting her phone under the elbow?
Yes.
Okay, let's try that.
We'll get started.
I'm going back up. I don't need to see stuff like that. It's just been on and on. I'm just done.
What's she saying?
They're scattered through these Texas, you know, just on and on through Texas, so. Got to skip a lot of stuff to get to the next.
Is there any way that we could do this another day and let my voice come back?
She said, is there any way to do it another day when she talks?
I suggest that the court could look at these, right, for the purposes of what we're doing here today.
Are there other messages that you don't want to show in the intervening thing? Is that what the problem is?
No.
She was also sending me pictures.
Wait, don't say anything yet. Wait just a second. Your lawyer will talk to you about that. Are you still there, Mr. Trump? Let me see your phone here for a second.
I mean, I don't have anything to hide. I'm just done with the name call. I'm done with the Facebook.
Don't say anything.
I'm sorry.
Did you get her some more?
She said, what you need to do?
Doing good.
Don't want to have.
I had stuff in my eyes and I lost it.
No, these texts are very involved, you know.
He had to use alcohol.
I don't know. I don't know what to think about those, and I think Mr. Cross have a right to examine them before I make any decision on them, and you have to pursue them. It appears to me that there's some conversation going on with these people about past relationships. He's sending her some pictures, and either he posted some pictures of someone alleged to be her, or she posted some pictures. I don't know.
Those are his girlfriend.
Those aren't you, there's. I don't think we can conduct a hearing and properly cross-examine her with her voice the way it is.
Can't argue with that.
Okay, so what I want to do is hold this in abeyance till next rule day.
We can pick up from where we are now, perhaps we can get this information off of this phone.
Yeah, that's what I'm saying. On March the 6th at the end of the
Your
hour.
Honor, the only, I think that's fair and reasonable and understandable. I would propose that until then, Mr. Captain A be allowed to bond out, or B, if that's not agreeable or suitable to the court, to let him do work release with Mr. Stern.
I have no problem with work release.
That's good.
No problem with work release, as long as he tells us where he's living, where he's working on location,
Yes.
not just out roaming around. So.
Do that every day.
So the location, he'd be let out and let in. They don't like that, the jail too much, but.
There certainly be something in the order, Your Honor, directing him not to communicate with the solicitor woman.
I said, District Court.
And not to go be around her.
Amen to that.
Of course, that's the condition of his bond anyway.
I'm not for sure.
Well, check the bond.
Probably it is before, but Jerry, I'm gonna come down and explain this.
Okay, wait just a second. Wait just a second. Does he have a bond in district court?
Sure he did.
Well, we need to check the bond in district court.
Yes, it's $100.
And what does it say, the condition?
No contact whatsoever with the resident.
Okay, well, here's the problem. I can't do anything about that bond.
But has he made the bond?
No.
Okay, how much is it?
It's $500.
Okay, I'm sure they'll make it wrong, that's fine. $500, there's no contact, is that all it is?
Yeah, well, we've had a warrant served on him here on a probation revocation warrant. So I can set a bond on that. The bond doesn't bother me as much as the conditions are. So I'll accept the district court bond amount, but put the condition on there that he is under a curfew and can have work release. He can get from his house. He goes to the church, the doctor, or work, okay? And stay away from any communication to her whatsoever.
And still report to probation and parole.
Still report probation and parole. Okay?
Thank you.
Okay.
Do I need to direct order in that regard, or?
Yes, and have it circulated to Mr. Hunley, and then we'll have the hearing on him at the end of the docket on the 6th.
All right, that's it.
Mr. Captain, I'll be glad to see you.
Okay, thank you, Doug.
Daniel Norris. Daniel Norris. She crying or something? Where is the victim's advocate today?
She's got to do the grand jury.
Thank you. But I'd go out there and tell her that the victim's advocate will be in contact with her, okay?
I don't have to wait, your numbers are fighting.
Yeah. Commonwealth versus Daniel Norris for sentencing. Are you Daniel Norris?
Yes.
Your birth is 1996.
Yes.
Last four digits of social security number 1043.
Yeah.
Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct, Counselor?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
I've never seen anything like it. Go back there and shut that door. On a plea of guilty, in under indictment 0046 for charge of escape second degree. 2 counts, he will receive 5 years on each count to run concurrently. On a plea of guilty on 24 CR 0046 for assault third, he shall receive a sentence of 5 years. The 2 5-year sentences for that will be 5 shall run concurrently. On a plea of guilty on 24 CR 0029 burglary shall receive 5 years. On a plea of guilty to CR 0020 in charge of theft and lawful taking over 10,000 shall receive 10 years. The 5-year sentence and 10-year sentence shall run consecutive, total 15 years. On the plea of guilty on 24 CR 0040 charge of burglary third degree, defendant will receive 5 years. On 40 on the charge of criminal mischief, he's received 10 years. On plea of guilty to possession of burglar tools in 0030 shall receive 12 months. The 5-year sentence in 46 and the 15-year sentence in 29 and the 10-year sentence in 0040 and the 12-month sentence in 0030 shall run concurrently for a total of 15 years. Serve 305 days in jail and the balance probated for 5 years. Defendant shall pay $3,867 restitution in indictment for $27,500 restitution according to the plea agreement in 29. First payment due pursuant to the agreement 30 days after being released from incarceration. Also, restitution shall be applied to 40 and applied to and then to 29. What are the court costs?
155.
$155, and they'll be paid $20 a month on top of the restitution. So how many days in does he have? Carson?
I'm pretty sure he's got all his days.
Yeah, well, the bank calculated so it could be released.
Yeah, he's got all his days.
When does he need to come meet with you?
He needs to come see me Monday morning at.
Well, can he see you before then? Because I'm not letting him out until.
I can go to the jail and see him this evening.
Carson is coming to this, the probation parole, come to the jail to see you this afternoon. After he gets you set up, I'll sign a document to release you tonight after you get under his supervision, okay?
Yeah.
Okay. You're welcome. See you. Barry Rhodes. Commonwealth versus Barry Rose. 24 CR 0011 and 24 CR 003. Are you, where's Barry Rose? Are you Barry Rose?
Yes, sir.
Represented by Mr. Cross, you're here on a probation revocation on 00011 and 0003. What does the Commonwealth have to say?
He's got a 5-year sentence on supervision cases. He was here previously. We had him assessed for special authority, and then he said it. He's playing that one, so that's all right.
Okay, I'll sign an order as soon as they do your orientation. You can get out and go into drug court, okay?
Yes, sir.
Okay, thank you very much. Plain County Jail, is there anybody down there that we haven't seen yet? It's on the docket.
Oh, sir, Your Honor, that's all, I think.
I can't hear what you're saying.
I said, no, sir, Your Honor, I believe that's everybody.
Okay, you got Mr. Cross says there's somebody this afternoon, Michael Taylor, is that correct? That's been continued.
Yeah, I would have been.
It's been continued. Wait, Cross, let me talk to the jail before you do. You can walk down there. Okay, you can take, the afternoon case off, okay? Now you can talk to Mr. Cross.
I just want to say, tell Mr. Taylor I'll be down in a little bit.
Okay.
Okay, yes, sir.
Does that include the criminal docket, what do we got?
One more.
Thank you, Your Honor.
You should have it.
We said a question with the bond, she is taking care of her children, not off her fees.
Mr. Stockton, you wanna come around?
What's the issue?
I don't know yet.
She gets her children, I think she's got her stuff with them. She wants to make sure the bond will admit that, to see if bond.
Yes, change the bond to allow her to take, ma'am, you talk to me, okay? You wanna pick them up in the morning, take them back, and then scoop activities. And Commonwealth has no problem with that.
Yeah, I know girls sort like that.
Yeah,
She can do that.
that'll be fine. Okay, you can make that conversation bond, okay. That concludes the circuit court docket for today until 1 o'clock, correct? Yeah, let's go off.
Yes, yeah. Yes.
Brown, when we call it child support. Brown versus Brown.
Judge, in this case, the arrears is 1279.81, whereas that 1,000 be paid on March the 5th. He filed
1,279 is your age.
1,279.81. That's 1,000 on March the 5th.
Yeah. Okay. Stockton versus Cross.
In this case, Judge, we're asking with the arrears 12,035 and asking 950 be paid by 3/5 of it.
Okay. Cabinet versus Estes.
I have an agreed order in this case that should be filed.
Cabinet versus Farrell.
Have an agreed order in this case and be filed.
Lower versus lower.
Agreed order, be filed.
Rodriguez versus Richardson.
I need to put something relevant on this.
Could you step in there and get that solid drink that's in there? What'd you say?
I need.
Swear the testimony that you're about to give is true. Oh, nothing.
I did.
Thanks, today.
Stephanie Wickham,
By whom are you employed?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar with the case we're hearing today involving Terry Richardson? Was a complaint against Mr. Richardson?
Yes, he was served November 6, 2024.
Okay, since being served on November 6th of 24, have you received any type of answer?
I think I can talk to him on the phone.
Explain to him what
Yes.
the motion was about,
Yes.
and, so what is the child support asking to that?
Asking for $853.11 per month to pay per month, the obligation begin to the rest.
Is that based on the Kentucky child support guide?
Yes,
How many children are there?
one.
One.
Okay. What do you want to do?
This one wasn't the, that's a break, that was Kathy's, Kathy's a bit of this, now she has new mower, so Stephanie's covered these last two, Kathy.
Okay. Cabinet versus Thompson.
Have a great order in that one, Judge, here's this, where it's Kathy's also.
That it?
That's it, Judge.
Thank you.
Good, let's go off the record. Are you going up Saturday? At 11 o'clock? See, Okay, Mr. Burkham, I guess this is your motion. We're on.
Yes, sure. Due to the nature of testimony that came out, just change or something.
Well, I don't, we're gonna have time to do all of it today anyway. I've cleared that affidavits, and I'm sure, I'm certain because of the nature of those affidavits, we for sure don't want to broadcast, which we're doing right now. And secondly, I would think that there would probably be some strong opposition to the testimony. How many witnesses are you going to have?
Your Honor, we would need, there's still ongoing investigations here. We would need, I believe, probably a subpoena to detective at some point, someone from the school, based on these allegations, but those investigations are still ongoing, so I don't think that the detective would be able to comment or anybody would be able to provide any meaningful input. So those are gonna be.
John, on a temporary matter, we're asking if there's some serious state threat, well-being children. And I think that issue could be addressed in chambers very briefly, based on affidavits and testimony of what he viewed on the video today. And it's the thought is in possession of Kentucky State Police, it issue a search warrant. You know, they consider the evidence criminal offense. And also that it can be really answered by affidavits or some, because mother portrays this video as nothing. Nothing. Really something.
What's the current situation after the last order? I mean, as far as the timeshare. What was that?
Every other weekend and one day of the week, as long as there's no sports. I think the main issue is the kids primarily for mom go to school here, dad lives in the rest of the county, so there's an issue.
Now, what
Actually, he actually lives last week.
Yeah, and it's your motion.
It's actually Wayne County, it's in Nancy.
Well, I'm familiar with all those lines that were there. And you want to change to him having full.
Just temporarily, and only until such time as the state police or this court can order an full examination of the phone, and will know the full content. There's enough that he has seen. He did not investigate the phone content of this one video. Some police apparently did not go into it because they didn't want to open up the apps subject to erasure. So we've seen what we've seen, and it's about to get a criminal search warrant for. And we don't want temporary testing until such time as that rest of the phone contents are before both parties in full.
And I think if that's the way that he wants to proceed, the most appropriate thing to do would be follow the tendency of use and neglect action, have social services conduct that investigation. If those things he's alleging, are actually true, there's actually some basis there, but think they would need to go through the emergency custody avenue. And I know I can anticipate Mr. Bertram's response, but
Because I've already told them, the response was we had originally prepared the hearing petition. And in my office, it completed all these registered with it. I called the county attorney down here, Mr. Raines, discussing to decide better off it quicker. And before this court, because I already had a custom petition fixed, and the district court may not go into that. And also mentioned the lack of staffing in DCBS. Yeah.
Well, we also have a lack, we don't have a family court here either.
That's.
So, we do not do dependency, abuse and neglect cases here in the circuit court. They're all done in the district court. So,
I follow a suggestion to get it before a court.
well, my suggestion is you take it back down to him. I guess their suggestion is you take it up to me, but somebody's gonna have to hear. And, I would rule in it appellate court, probably ultimately anyway, so. Well, I'll put y'all, we have a short docket. And I'll put you at the end of the docket. And I'll clear the courtroom at that juncture, and then we'll see what we're doing with it. Take a look at it. I think the allegations are severe enough that without taking some look at it, I can't overlook it to the point where we just pass it off for 30 days now. Now, I'm not using the commissioner at all. So and I have time to look at things and do things. So it won't take that long to set up a full hearing. But I don't want to do anything final today without letting everybody in and all their witnesses. Now, I don't really understand what you're waiting to the state police do an investigation. I have no certainty as to when that might happen. So that's not very good as far as I'm concerned. Wait, let them, well, unless you wanted to have some temporary action, a temporary order but I don't know if they'll ever take it up, and you don't either.
You're right, and I have talked to the state police about that, and they said they're not opposed to this court allowing the parties to obtain income assessment of Congress.
I'm sure they're not, everybody you're talking at this point, wants me to do it.
Right.
Well, I'm talking to telling you that I'd rather somebody else do it, but I don't have the choice. But if you give the state police a choice of having, and I love the state police, but if you give them a choice of letting something like this be handled in the circuit court or them opening up a criminal investigation, unless it's a pretty egregious sort of thing, they'll go with letting the parties go forward, expert witnesses, things like that. And when you get into electronic expert witnesses, you're talking about a big purse item, So I don't know. Okay, well, y'all just wait till the end of the docket. We'll get to you, okay?
Thank you.
Kentucky Bar Bureau Mutual Insurance versus Richard J. Mason.
Yeah, Your Honor, I see John, you on behalf of the plaintiff. This is a motion for summary judgment as to the defendant, Richard Justin Mason.
Is there anybody here in opposition to this? Okay, I've read it, but just for the record, just say a few words about this.
Certainly, Your Honor. This is a subrogation action arising from a motor vehicle accident that occurred here in Clinton County. Richard Mason was the operator of the uninsured motor vehicle. He filed a pro se answer once he was served. We responded by sending him a number of discovery requests and interrogatories, request for production and request for admissions. He did not respond to any of those discovery requests. Those requests for admissions were deemed admitted pursuant to Civil Law 3601. Paragraph 2. There be no material issue of fact in dispute. We attached an affidavit as to the damages and then all the documents that support the figures outlined in the plaintiff's complaint.
I never understand for the life of me why people don't want to spend just a couple of $3,000 to get an attorney to respond rather than get a judgment against them. I don't know. I see it happen in criminal court where people aren't eligible for public defenders and have pretty good jobs, and evidently years of their life aren't worth that much, Okay, did you electronically submit the order?
Could have been one electronically filed.
Okay, we'll enter.
I have one here if you need it. This is Mr. Mason, I guess.
Yeah, Mr. Mason. You didn't file any answers to any of that. Well, what's the deal?
I've got mine here.
Do what?
I've got one.
You've got what, your answers to these interrogatories? See, why didn't you get a lawyer? Well, they have sent these requests for admissions and interrogatories that you have to answer. And a request for admission has to be responded to within a few days, or they're admitted. And you didn't respond to. Do you have a file?
Say answer to the complaint.
Yeah, but I'm talking about the request for admissions. Well, you know, that's the reason you should have gotten a lawyer. Okay, they filed a complaint against it and you did your own written response. And after you did the response, then you serve a request for admissions and interrogatories, questions to answer. And you didn't respond to those.
I got two things back.
I can't hear you, I'm sorry.
Two things back in 2020, and then I got on Saturday. Well, what you got on Saturday apparently was the motion for summary judgment.
Has it been 2020 since you did the request for interrogatories? When was it?
It was, and we did skip tracing to make sure that it got proper notice of the motion.
I'm thinking,
this is an answer to the original complaint, it appears. Because it's. Where did you get the form to file this? No, I'm talking about your answer. Here's his answer that you filed, pro se answer. Who helped you prepare the answer you filed to this? This thing here, huh?
Myself and my mother.
Is she an attorney?
She worked for an insurance company.
Jeez. If I give you 15 days to have an attorney review this, I'm gonna have an attorney to respond to this motion. I should go ahead and probably enter the summary judgment now, in all probability I will. I just want to see if there's something that is so egregious that there needs to be some response to it out of a sense of justice. So I'm gonna give you 15 days to get an attorney and serve counsel here with any egregious sort of objection in the judgment or not. In all probability, there's gonna be some judgment, and if you don't give some egregious sort of reason why you shouldn't get entirely what he asked, I'm gonna enter it, because I think they're entitled, but it might be something that plaintiff's lawyer overlooked or miscalculated or whatever, that is an egregious, that I don't want to enter because you didn't admit. So with 15 days today, I want you to serve on Mr. Donahue a response from an attorney. And if you don't serve it, I'm going to go ahead and enter this judgment as he submits it now. If you do serve it, I'm going to give him an opportunity to respond to that. We'll be here on the next rule day on March the 6th. Okay. And then we'll have a hearing on it.
We're not working with water or things. So busy right now.
But anyway, I'll give you more days.
No. I mean, really, I'm going outside on the edge of what I can do to give you a break here. Just because once you start having to pay this, you know, I want you to know at least you had some opportunity. It might very well be that the responses to the request for admissions would have had to been admitted. And I think at least you'll have a sense if you were treated more fairly, not that you've been treated unfairly, if you find out from an attorney that you would have had to admit the request that Mr. Donahue made from you, and it wouldn't have made any difference. You understand what I'm saying? Okay. Will
Can
you
you confirm the correct address? 'Cause when we skip tracing, we sent the two different addresses.
Okay, tell him what your address is. Okay,
What was the date of the hearing?
the date of the hearing is March the 6th, if one is necessary.
Okay, I'll be, not available on March.
What about April 10th?
Is Zoom available on March the sixth?
Zoom is available.
You do March the sixth.
And since you made an appearance here personally and for inconvenience, we can make arrangements to do that with Zoom.
Okay, I would appreciate that.
Okay, we'll do that on March the 6th.
March the sixth at 1:30.
That would be correct. Could be
15 days.
15 days for him to have an attorney respond to you as far as which request for admission could very well affect the outcome of the case.
Okay.
You know, and then if there are any interrogatories that need to be answered to give them that information, at that juncture, you might enter into some negotiations with them if there's some real issue. If not, you know, they'll have a judgment, okay?
Okay.
Thank you very much.
That 1:30, Joe, March 6th.
It's, let's do it at 2. Because we'll go through the docket a little bit.
Okay.
Okay, thank you very much. Philip Diablo versus Kimberly Hadley. Where's the other side here?
One next. Oh, sorry. I didn't recognize the Diablo last name.
Maybe I said it wrong.
Danglo. Sorry about that.
It's not that different. It's like Poindexter and Pinedexter.
It is.
Okay. What kind of case, what if y'all hone down the issues you want to try on this?
Judge, this thing is, there's an underlying issue here is a breach of, failure to disclose certain defects in the home. We've filed a claim, we've exchanged some discovery. Case was kind of, off the side, as it was pending foreclosure action on the house in question. And the sale has occurred, so now that we have kind of market value and some of the things that we need to address the trial, we would just try and ready to go. So.
I think we need to do some depositions, but we can set a trial in April.
I don't set any trial dates until depositions are finished. You know, because I can set it, but by not doing that, I can set trial dates more quickly for everyone. So there has to be a declaration that all depositions are taken and all expert opinions have been gathered, and then I can set you a trial within 90 days on any kind of case, unless I had some very complex cases, and we don't get very many of those. What sort of, I've looked, I don't have much detail on the deficiencies in the construction of the house.
This is an existing structure, Judge, and we're talking about defects to the.
Unforeclosed defects.
Undisclosed defects that will be known to the seller, known to the seller and that failed to disclose those.
What kind of things were they?
We're talking about, water mitigation, where there was water that had been infiltrated the home, caused considered structural damage, it's the in-ground home. There is issues with the roof, there's also issues with, rot with regard to wood and various other things.
Did your clients get an opportunity to inspect the property?
He had an opportunity to inspect some of the property, yes. However, it was totally also based on prior to that inspection that this Crabtree had made her standard disclosure form. And a lot of the issues that said that weren't there were indeed actually present.
What do you have to say about it?
Your Honor, there's actually at least one paid home inspector who did an inspection for his client. And I believe there's also an inspection done by the VA as part of their loan. One of the issues that's gonna come up, I think, in the deposition is that he had either filed bankruptcy right before he filed the suit, or he filed bankruptcy right after he filed the suit. The home was given up into bankruptcy, and so we're gonna be arguing standing, to even pursue this, once we get his deposition.
And in response to that, I've had conversations with the trustee and not relinquish this particular claim regarding the court action against the house. Although he did relinquish his ownership interest, he must maintain the suit. The bankruptcy was filed after the complaint had been filed. The trustee did not, basically claim usurped any rights that he would have sounding tort or sounding kind of breach of contract claim as it would be against the seller. So it's not a full relinquishment, relinquishes property interest, no doubt, but.
So I would think the trustee would want to capture it.
I have.
You know what I mean?
Yeah, written correspondence to the effect that the trustee is not, was allowing me to pursue, actually had an appearance in bankruptcy court to let them know that I was pursuing this, civil action in your court, you know, so,
Whose deposition you want to take?
The purchaser, his client.
Okay. Well, I don't want to drag this out.
Right.
Okay. Y'all get your calendars together and see if y'all got a date available this month sometime. We'll take a deposition on that.
the only problem there is my client is actually, he's a disabled veteran, he's had to move back to Las Vegas with his family, and that's been some of the problems of trying to get him able to get back
He
here.
doesn't have to come back here. Y'all can go out there.
Well, that was the request we had made. We were hoping that if there was going to be a deposition made, the request that he needed to be here in person. That we're just not.
It wouldn't bother you if he did it on Zoom or something like that, as far as the deposition was concerned.
Yes, sir, we'd like for you to be in person.
Well, I know you like that, but you know.
To pursue a lawsuit here, he's gonna have to be here for the trial. So we.
I didn't say he wasn't gonna have to be here for the trial.
Well, and so I believe that he would have to be here, for the deposition.
I'm just asking you if you'd be willing to do it. That's what I ask you.
Oh,
You'd be
no.
willing to take him by Zoom
No,
since he's a dis.
For it to be live.
I know you would prefer that. I'm just asking. So your answer is no.
Correct.
You would be willing to do that. So.
And we'll have to make arrangements, and there will be some costs associated with that, but, if that's what the court orders as far as when we meet his deposition in order to set a trial date and.
Well, I'll tell you what, I hadn't really, with all the Zoom changes and the rules and that sort of thing, I haven't really been faced with the proposition of whether someone, if it's out of state, very expensive to get them here, whether they can be deposed by Zoom. We can do virtually everything else by Zoom or something else. And so I want y'all to give me, each one of you to brief that issue to me before I decide for sure, because I'm not saying you're not correct on that, Mr. I'm just saying I don't know. I haven't been dealt with that. So each one of you, let's say, within the next 5 days, give me some authority on whether or not you're, what sort of hardship you should need to express, or if there's a hardship exception to letting him do it on Zoom. And obviously you need to tell him he's going to have to be here for the trial.
He's anticipating that. It's just the double dip there.
Well, I understand, I understand. And fortunately, I hear that Las Vegas is one of the cheapest places to get back from if you don't stay too long. Okay.
But yes, we'll bring this.
You might be able to get some of these low price airfares from some of the exhibitors there back, inexpensively.
Unfortunately, this time the house is left in broken pins.
Yeah. Well, you got a lot of friends over in Russell can't have jets. Maybe they do.
Oh, I'll get one Monday.
Yeah, okay. Okay, well, y'all give me this information within the next 5 days. Then I'll make a decision on whether or not we can do the deposition by Zoom. If we can't do the deposition by Zoom, then we will need to, y'all need to schedule deposition. I really don't think this will delay it that much by giving me that information. I'm sorry, I don't know that answer to the question, but I'm just bored on it, okay?
Yes, sir.
Thank y'all very much, yeah. Tracy Huff versus Edmund Brumley. Okay,
Afternoon, Your Honor, Malcolm Sutton.
yeah, good to see you.
This is my motion, Your Honor. This case has a long history. I don't remember if you recall it. We originally, Kentucky Growers originally made an offer to sell for $150,000. Ms. Huff fired her attorney. She filed an attorney lien, and then AC showed up with his judgment from Pulaski County.
Remember that.
And then the court was, and I ended up settling with her for $75,000, just her. And the court was a little skeptical of why she did that. And then the court suggested that we pay in our original offer of $150,000. So that's what I'd like to do, is to pay that to the court or to the clerk, and you disperse it as you see appropriate.
So I can update you. Ms. Marley, who's a former attorney from this, and I have been working, trying to deal with the humane and medical liens. She got those resolved for $17,712.30. Then we had some discussions on what we could do to help Ms. Huff come out with a little something on this, and we offered, Kentucky Farm Bureau offered an opportunity for her to have her license reinstated in the Pulaski Circuit case, and using the proceeds from our non-wage garnishment that attached to the settlement proceeds as a down payment, allowing her a very minimal monthly payment without interest on the judgment. And Ms. Marley communicated with me that she had gone over all of those details with Ms. Huff, and she accepted those details. I was informed, I think, yesterday or the day before, I hurriedly drafted all the paperwork necessary for the Pulaski Circuit case. Sent that to Ms. Marley and her legal assistant.
I heard it on format.
For the counsel involved in this case, I did an agreed order that addresses how those $150,000 funds will be dispersed, and then dismisses the case with prejudice. And then I've got signature blanks for everybody involved, including Ms. Huff, to sign.
Judge, I'm standing in for Ms. Marley. I can confirm that, Ms. Huff is aware of all the details that Mr. Hoppy has gone over.
Well, can you affirm to me that she will sign it?
She's indicated that she will.
Well, I have a lot of people indicate they're gonna do things. I'm a little reticent to enter an order till I see the signature. You know, you're happy with that?
Yes, sir.
You're happy with that, and you say she's gonna be happy with that. But of the three of you, I'm the happiest.
I'm going.
Because as they say in Monroe County, it was a gommed up deal. That's a legal term that you'll learn if you go practice in Monroe County. It's a gommed up deal. So as soon as y'all send me that order or email me that order with the signatures on it, I'm not doubting what you say. I'm just doubting, I know human nature enough to say that people will back out over $5 or something sometimes, okay? So send me the order and y'all can be on your way rejoicing when I see it, okay?
Yeah.
Okay, thank you very much.
Thank you.
Thanks, Judge.
Yeah. Okay, Independent Capital Holding versus Burkesville Road Properties LLC, NGL Supply Wholesale and Mid-South Capital. Motion is withdrawn, okay? Notice of ruling and motion for entry of decree of dissolution. Chanel. Beach, and now I'm familiar with this. Have you ever gotten him to sign anything or do anything?
No, we sent him a notice again.
Hello?
He's not responding to me. I think he tries to contact her.
And do you have proof that he received that?
I sent it.
I was gonna enter an order the way you proposed and give him until today to file any objections. Isn't that the way it came down?
Yes, we sent it to different addresses, his employer and to the home where he still goes and gets his mail.
Has he made any statement to you that he received this? Okay, will you raise your right hand? Swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth. Okay, just ask about statements that he might have made as to whether he received notice of this motion.
Your Betty will thank you. And we were married to Cornelius Stolpe. And we recently been in court in January regarding the motion for the fall divorce. This is arguing property and custody issues. And since we were in court in January, has Cornelius Stolpe had any contact with you indicating that he received notice of the documents? Yes, he didn't understand everything he asked for. That is since we were in court in January.
Okay, well, I gave him the opportunity to come forward and with any exceptions he made, and he failed it, so send it to us and we'll electronically file.
I've got a copy. I think I e-filed one as well as here's the hard copy.
Okay, we'll enter it one way or the other, okay?
Thank you, Your Honor.
Thank you very much.
That's all I have.
Absolutely. Asset Security Consulting LLC versus WW.
Afternoon, Your Honor.
Hello.
He set out for Asset Security Consulting LLC, and next to me is Wade Weston, Mr. WW. I believe his counsel is present on too.
Yep, Your Honor, Joseph Kramer here for Mr. Weston.
This is a structured settlement transfer petition, Your Honor. He has a structured settlement that resulted from his father. He'd like to sell part of it. He's sought out and obtained independent legal advice, and financial advice, which he can tell you about.
Okay, which one of you gentlemen that have your cameras on is involved in this case?
That'd be me, Your Honor.
Okay, well, other counsel, turn your camera off to your case is called. Thank you so much. It makes it a little bit easier. Okay, Mr. Kramer, are you making an appearance for WW here?
Yes, Your Honor. So we entered our appearance earlier this week.
How did you come in contact with Mr. WW?
We actually represented him on a previous transaction as well.
With this, where he sold another part of his settlement?
That's correct, Your Honor.
Yeah. Now, sir, how did you contact Mr. Kramer in the first place? How did you know Mr. Kramer? So you did it yourself. Nobody provided you the information. Is that correct? Is that what you're saying? Yeah. Okay. And Mr. Kramer, have you reviewed the documents that have been presented on behalf to your client as far as selling this structure?
Yes, Judge. Yeah.
Okay. And do you believe it complies with normal transactions in the field and not more onerous?
Yes, we do, Your Honor.
Yeah, and he's had plenty of time to consult with you.
Yeah, that's correct. So he's consulted with us and then also his financial advisor as well, Judge.
Okay, just submit the order.
Your Honor, I can take one and I have a hard copy here for you also.
We'll probably just give us the hard copy. We'll probably e-file it. Okay, thank you very much.
Thank you, Your Honor.
Yeah, absolutely, be safe on that. Steve Anders versus Gary Wallace. Wasn't there a bankruptcy filed in this case?
Yes, Judge. This is Nick Wallingford on behalf of the plaintiffs.
Yes.
There are two cases on the docket. There's one motion that was passed on the 24 CI 104 case. But then my motion for certification in the 23 CI 58 is still on the docket.
I was advised everything was withdrawn today. I think Megan was pulled to it.
Yeah, I was confused. Yeah, the other one with Miss Sawyer's was withdrawn. But I'm assuming this one wasn't. There's two different cases.
Just certify the judgments of the bankruptcy court.
Just certify the jury, probably what
Tell me exactly what you want to do here. These other attorneys are at a quandary here.
Oh, Your Honor, I'm sorry. I'm trying to hear them. If they could step to the microphone a little bit, but
I whispered together and I couldn't hear them either, but I a perplexed look on the face. So just tell us what you want to do today.
This court previously entered a judgment against Mr. Wallace in the amount of about $770,000 in a previous hearing that we're moving to certify to make that a final and appealable judgment. This is an issue that's come up in both the bankruptcy hearing and in that foreclosure action, and we just want to get closure on this situation. The other matters that are going on in the bankruptcy court are now subject to that automatic stay. So we're seeking to certify that judgment at this time.
In response, Your Honor.
Speak up real loud.
Yes, I'll use my outside voice if you'd like to say. Your Honor, the court recalls entering this judgment against Mr. Wallace in the midst of various claims and cross claims and counterclaims. And it was never intended on being final and appealable at the time, because Mr. Wallace had claims and we were going to let the thing run its course. Now, the company's in bankruptcy and the state would have to operate where nothing could be done. And it's first time I've no disrespect Mr. Wallace. We've been dealing with Mr. Backert on this in the bankruptcy proceeding. The company has a bankruptcy attorney, Mr. Wallace was blind. Somehow put the company in bankruptcy, and I don't really know why Mr. Wallingford would be here today if we're in bankruptcy court. And if he could explain better, so be it. But I respect the state of bankruptcy court, and what he's wanting you to do is something new and different. It's not certification per se. It's making it a final and appealable order, which what can we appeal? We can't appeal anything if there's a stay.
You can come over and say anything?
I'm here for observation purposes. Obviously, I'm here.
Are you a party?
What's that?
You represent a party?
I do. J3 Packaging is also my name as a defendant of action, and we were made aware of this today.
The judgment wasn't against you, though.
Not
so-
against us.
Okay, okay, I just want to make sure I gave you the opportunity. What is the purpose of you seeking certification of this? Let's just like lay them out there. What is the purpose? What is this?
Your Honor, the certification.
Does this violate, I don't want to get crossways with one of them federal judges down there in Bowling Green.
Your Honor, the automatic stay only applies to Dale Hollow Charcoal. This is intended to tie up loose ends. That the certification of that judgment, making it final and appealable, will essentially bring closure to the pending issue that's against Mr. Wallace brought by Steve Byer in Twin Oaks. That Mr. Cross raises an objection with respect to the automatic stay, and that automatic stay only applies to those claims that involve Dale Hollow Charcoal and are brought against Dale Hollow Charcoal. But this motion is intended to make that judgment final and appealable and tie up those loose ends that remain strangling kind of in this Clinton Circuit Court case.
Your Honor, Mr. Wallingford is correct. The stay only applies to the company, but the company was a party to litigation. And as previously stated, there's counterclaims in this thing, and what Mr. Wallingford is trying to do today is terminate that litigation with Mr. Wallace's claims yet to be litigated, yet to be a final disposition. There's offsets, there's a lot of issues. So I think if he wants to get it so-called certified and final, we're gonna have to litigate.
Let me ask you something.
Yeah.
Your client, who you represent today,
Today, Gary Wallace,
okay, and that's who the judgment.
that is correct.
Well, is if what happened if Gary Wallace entered into bankruptcy?
Which he's correct to do for 6 months. Well, if he.
Well,
if he
and
went to
that
bankruptcy,
would,
stay.
I mean, rather than waste any time, if he was in bankruptcy, it would be out of my hands.
Yeah.
And if I sign this certification today and he goes into bankruptcy, it's out of my hands.
Correct. But if you sign it, the case is over. That's the way I would view it, because we've got unfinished business. Let me give you a little broad overview of this, if I may. At present, Dale Halla is in bankruptcy court in the Western District. Dale Halla has an attorney supposed to be impartial, but was selected by Mr. Byron. Mr. Wallace has an attorney in bankruptcy, Robert Shadow. Mr. Backer represents Mr. Byron in bankruptcy. We're in the process of all trying to negotiate a settlement through Mr. Backer. And then Mr. Wallingford, who fine fellow, but where'd he come from? And I don't, Mr. Wallingford hadn't been seen or heard of in several months, and we're trying to resolve this thing, and all this is going to do is complicate it worse.
I don't think that's possible.
Oh, well, I don't think it's correct. I don't know. But I think that there's, as I say, unfinished business regarding the counterclaims. J3, it's a real mess, and that's why we're trying to get it settled.
Your Honor, I believe this motion promotes settlement.
Well, it is, probably does permit settlement, just like if you handed somebody a hatchet. If you were in a fist fight, it would allow settlement, I guess. I remember signing this. I don't have any reservations about the fact that I signed it and the judgment was not made appealable at the time. I didn't understand why at the time. Usually a judgment of that size, you make final and appeal, unless there was some intent to have cross claims and counterclaims involved, but nobody's ever come in to try to do that. That's what bothers me. You know, I mean, they have,
Why?
well, that somebody needs to.
Because, Your Honor, this case has been subject to, since we were here on that 2 days of mediation with Pleas Gambit, which was untrue, sorry, which was, and Pleas pretty good. Much negotiation between Mr. Wallingford and I, and then we get this bankruptcy. And for the last, 2 months or so, Mr. Wilkerson, we've been, and I, court knows Mr. Backer every bit as good as I do, and he's good to work with regarding resolution of claims. But the last emails we had is that he and I were attempting to reach some sort of an agreement between my client, Mr. Wallace, and it may end up involving Mr. Wilkerson's client. We don't know. But if you sign this today, we're going to have to file a notice of appeal on it, because it does not need to be final, because there are too many counterclaims pending on Mr. Wallace, because court, we believe the court was in a tad of a hurry in doing this with all the counterclaims and such that we had. And those need to be presented if we can't get it set.
Well, let me tell you what the situation at the court. The court reviewed all these parties, the interrelationships with the parties, the dealings with the parties, the marketing agreements with the parties. And I was dealing with a party that had invested a substantial amount of money and assets and didn't appear to be getting anywhere. There was a vapor on who owned this and who owned that and that sort of thing. And it appeared to me that the one thing was apparent is that this judgment was appropriate if any advancement was going to ever happen. If the people who invested the money had any hopes of recovering any of it, because it was obvious to me that there was never going to be an agreement worked out where these people could all work together.
Well, I agree that they can't work together.
They cannot work together.
That's absolutely.
So the issue would be, and I never saw any really strong argument. Now, who would have the counterclaim that would affect this or the Crawford?
Mr. Wallace asserts, and I don't have the plea in front of me because I understood yesterday everything was on. Gary has various claims against Mr. Biden pertaining to the money that was invested in what Gary had done and Bill. We assert that there would be, first of all, we acknowledge that Mr. Byers put a lot of money. We don't agree it's as much as the courts have entered judgment for. Secondly, those should be subject to various credits and set-offs for various reasons as we continue to set forth in our counterclaim. That's what we need to litigate if we don't get it set. And we're still trying. We might do it, we might get it done. I don't know, but we haven't yet.
Well, Mr. Wallingford, what do you have to say about the denial of Mr. Cross's clients of being able to proceed with any offsets or credits that they might have against your judgment? What forum could they do that in? Is that a fair question, Mr. Cross?
I think so, Rob. Yeah.
Well, Your Honor, you already addressed these offsets and credits in this court. Mr. Wallace claimed that about $50,000 was taken from Dale Hollow Charcoal from Mr. Byer. We showed through records that those funds were actually remaining within an account at Dale Hollow Charcoal, and that Dale Hollow Charcoal was like casually referred to as the QuickBooks account. So they were funds that remained in the possession and the custody of Dale Hollow Charcoal the entire time. And we addressed that issue during our motion for summary judgment. So that was the only claim of offset or credit they had.
Yeah, you know of any, can you name any offset or credits are entitled to Mr. Cross?
Your Honor, I apologize. Mr. Wilkerson was kind enough to call on me because nobody else did. And I scurried over here to try to address this. Until I had my father this morning, back to the office.
Well, did you file an answer to this motion? Okay, well, here, since this has been such a complicated sort of thing, I'm going to give you 10 days to file what sort of cross claims or counterclaims you think would be unaddressed. But the problem that I have is this judgment has been laying out there all this time and nobody's done that up to this point. So serve on Mr. Wallingford this, and Mr. Wallingford, you will help me rebuild this complicated process that we've been in and give me a reason why there is another forum that can be addressed, or why Mr. Cross's client missed the opportunity to get those offsets. You follow what I'm saying?
Absolutely, Judge.
Okay. And you do that in 10 days and you take a look at it, and I'll give you 10 days to file the answer. And then if y'all need to be on the next docket here on March the 6th to help me lead me through this briar patch, we'll do that. In the intervening time, there's always a possibility that your client could do a bankruptcy situation.
Oh, and he's.
Well, I mean, you need to, I can't decide.
Want to, but.
Well, I don't want to. I do a lot of things every day I don't want to. So in any event, there's where we are. We have 10 days and 10 days to respond, and we'll be back on the docket for a report on March 6th. Okay? Okay,
Thank you, Judge. And thank you for letting me appear by Zoom today.
Yeah, thank you. Okay. Did anybody ever show up on the Russell County case? They didn't withdraw that, they just didn't show up, I guess.
Your Honor, we're on Zoom.
Okay. Defendant's objection motion to quash plaintiff's notion. Okay.
Yes, Your Honor, Lindsay Porter on behalf of the Russell County Board of Education. Your Honor, if you'll recall, in August of 2024, I filed a motion to set this matter for trial. However, as this court's aware, you prefer depositions to be completed before giving counsel trial dates. So you entered an order on September 10th, 2024, which basically outlined that opposing counsel had 10 days to provide a list of witnesses in which they wanted to depose. And further, the order said that the depositions needed to be completed within 45 days of the entry of that order. That did not occur, Your Honor, and now we received a notice of deposition of certain school personnel outside the time frames of that order. And so we are just requesting that those notice to take depositions be quashed.
Your Honor, this is Joel Smith representing the plaintiffs in this case.
Joel, do you have anybody there that can show you how to turn the camera on?
I think I've got one coming to the forefront right this minute.
And Your Honor, this is Anna White. I also represent the defendants.
Okay.
I mean, plaintiffs,
There
sorry.
you go, Joel. I mean, you and Elmer George are the last two people I've got that can't turn the camera on. Well, Ted Lavitt has trouble with it too, so.
Well,
okay, what do you have to say about you're not following that order?
Well, first of all, I want to say that I think it's the obligation of opposing counsels in these cases that we try to get these things resolved. Along that lines, we did have you to ask you to set up a time schedule for where we could do depositions and get all of those things behind us. One thing that we had.
Isn't that what I did? We've given you 10 days to give notice and then 45 days to complete the depositions. I mean, you don't deny that order was entered, do you?
No, I don't doubt that. And
why did you not comply with the order?
Well, I take umbrage with counsel's comment. The fact is, on September 20th, 2024, I made an extensive list of plaintiff's witnesses, and that covered 6 pages, and that was filed in the file. I'm sure there was a rather liberal amount of numbers of people that we think are very important to this particular case. And when did
you file it?
When did I file it? September 20.
Okay, was that inside the 10 days?
But here's the issue, Your Honor. That witness list doesn't identify the individuals to be deposed. It was 38 plus witnesses. And it didn't say, I intend to depose all 38 of these witnesses. I even sent him an email on September 10th that said, which witnesses do you intend to depose? And no one responded.
I don't remember seeing that, Judge, but I will say that in the preamble to the witness list, I said, comes the plaintiffs by through counsel and provide the following witness lists. Now that's pretty clear. But if I can proceed, Judge.
Well, how many of those people did you plan on deposing?
I intended to take all of those. And I followed that up with the notices to take those depositions on January 9th. The problem is that it wasn't a problem at the time. We agreed to get into a settlement negotiation after filing the witness list that has been brought up. In that period of time, we prepared to get together and see whether or not we could create a settlement.
Your Honor, this is Anna White. I'm co-counsel for the plaintiffs, and I came into the case after the expiration of your order. I'm probably partially responsible for the delay because I wanted to get up to speed and also review the school board's discovery so that I would be able to narrow down potentially the 30 folks to depose. And I also reached out to Ms. Porter and Mr. Smith and I kicked off some settlement discussions with them, which took up some of the time. And following those settlement negotiations being unsuccessful ultimately, although both parties did participate, we sent them a settlement packet. We had some back and forth. They made a counter offer. When that was unsuccessful, at that point, Mr. Smith went ahead and started noticing the depositions of the first, I believe, 4 people that we as co-counsel believed are the most vital to start deposing. We'd prefer not to do 30, and we would prefer to get it done promptly. So we thought we'd set them in January based on those depositions. We'll be able to move ahead.
Let me stop just for a second.
Yes, sir.
Have you made a decision on how many of these people that you plan to depose now?
We have not, Your Honor, but my best initial guess would probably be 8 or 10 at most. And these will primarily be very short depositions. It's just a very fact-dependent, witness-dependent case, and I know the court does not want us to subpoena 30 people and have them give their initial testimony before you. We prefer to narrow that down in advance of getting into a courtroom.
Well, for short witnesses, I don't have anything else better to do than sit there. I am inclined to violate my own rule and just go ahead and set it for trial and let you call 30-some people. You know?
Well, Your Honor, I would appreciate not having to do that. I think it's in the interest of perhaps getting this case further to settlement to take some of these statements so that the defendants are maybe a little more aware of the facts that we have argued in the complaint and are trying to follow up on.
The defendant's not asking for the opportunity to depose anyone. So if you're making some altruistic proposal to help the defendant, then she doesn't.
No, sir.
Also doesn't need to be, she doesn't seem to be to want your help.
I'm not, it is not altruistic. It is that I believe they will come closer to or come back to the table on settlement after we get a few depositions under our belts and they hear that testimony.
He says they're not going to do that. And so, yes.
If I may very briefly, your order said for depositions to be completed by October 25th, 2024. We have prepared a dispositive motion at this point. We completed our depositions. This case has been pending for years. So at this juncture, we're requesting that your September order be honored by this court.
Yeah. Well, that's the reason I get in problems sometimes signing orders. You know, and once I am asked to enforce the orders, you know, they don't look as good as they did when somebody doesn't comply with them. And when people comply with my orders, they seem to have been a brilliant idea. It moves it along. I'm fair to everybody. And then when somebody refuses to do that, then what you're asking me to do, you want a dispositive, you want me to throw the whole case. That's what you're doing because they didn't. Right?
No, Your Honor, I'm not asking you to throw the case. I just feel that this case has been.
What relief do you want? Tell me, you want me to keep them from taking these people or excluding these people as witnesses?
They can call them at trial, Your Honor. They can call all 30
So you have no objection to calling them at trial?
No, absolutely not.
I'm just asking you, don't be surprised that I'm a little slower. I'm down in the country and I think a little slower than you do. Okay, so I'm just wanting to ask you what you want. And it appears to me that you're entitled to go ahead and get a trial date. And if you want any of these other people, if the only reason, Ms. White, that you want to, counselor, if you want to take these is to help the defense lawyer decide that they might want to settle, she says she's not interested in that. So if y'all got you got your calendars out here, we'll set it for trial. And Mr. Smith, you can call any of these people you want to. Okay?
Thank you.
I just want to make sure we were all clear on that. Because you didn't call.
And Your Honor, may I just put on the record, that isn't obviously advancing settlement is what we would like to do. So we would like to depose these folks. It's also difficult coming late to a case. to not be able to conduct discovery. I believe Mr. Smith argued some excusable neglect in his motion. He's a solo and some ill health delayed his taking those depositions within that very brief window. So again, we'd argue, we believe it's appropriate, yes, to set a trial date, but also to give us the opportunity to depose a few folks.
Well, I'm not always right. And so you've got it on the record and I'm not always right, but I'm very seldom in doubt. And so I'm not in doubt in this situation. It's time, as you say, to resolve this issue. I don't have a tendency to push civil dockets as much as some people do. I push the criminal dockets to make sure they're there, and I don't schedule trials until everybody is ready. But everybody's had an opportunity to get ready, and I don't think that you will be prejudiced by not being able to call these people. I just want to make sure that, so we can call them if it takes 5 days. You know, we'll call. Everybody got their calendars out here.
Yes, Your Honor.
Judge, yes.
Is June too soon for you guys?
No, Your Honor.
Okay, how about June 2nd, 3rd, and 4th? I'll have to stop for a motion day on the 5th, and we can come back on the 6th if we need 4 days.
Judge, Judges, Joel, I have a trial of the case of Popwell and Kelsey versus Corner in Russell Circuit Court, beginning on Wednesday 4th through the rest of the week.
How long has that case been out there?
We went all the way to the not United States, Kentucky Supreme Court and back, and just now are getting back on track. So it's been around a while.
Okay. Well, how about June 23rd, 24th, 25th?
That's fine.
And then have the 27th on reserve. Ms.
Your
Porter, is
Honor,
that all right? I can't hear you now, Ms. Porter.
I'm not available that week, Your Honor. I apologize.
Okay. Looks like I'm the only person that has like a Wyoming sort of schedule. It's completely open all year. Okay. Let's take a look at July 14th, 15th, and 16th.
Works for me, Judge.
Yes,
Your
sir.
Honor.
Okay. They are, will we need, is there any, you think there are gonna be motions that we have to have about any pretrial situations or anything, or are you just ready to go?
Your Honor, I do intend to file my motion for summary judgment.
Okay. Okay, well, what I want you to do is I want y'all to file some proposed instructions by maybe 45 days out, proposed instructions, so we'll hone down the issues that we are going to try to put in front of the jury. I don't want to get them out there and just do one of these let them lay where Jesus flings them sort of thing. I want to determine what issues we're going to submit to the jury and your authority for submitting those. And then for my own information, I want to know what you think the witnesses are going to testify. And if there's two, and I will not change that, but I just need some kind of guideline so I'll know how to schedule my time that week. And then if there's any case law that will impact, after we get past the summary judgment sources, I'm sure you'll do case law with your summary judgment motion, I'll look at that, but if there's anything else that needs to be resolved, we'll do that, okay?
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Honor.
Okay, thank y'all very much.
Right.
Okay, now what do we have left here? What do you have here?
Judge. Jim Thomerson, defense counsel, Littrell versus St. Thomas Wind Resort.
Yeah.
It was actually,
Yeah, oh, yeah.
That's my motion to dismiss, Mr. Cross. When I emailed him a copy of it, said he was on accordingly, I'm not got him his fault.
See where Cross is. Is he back here in the room somewhere?
He went out.
Get him on the phone. Jeez. We'll find him. Can you see if you get Cross on the phone? No idea.
Is David over there? Oh, the judge is leaning him over and put.
Tell him what it's about.
It's on his case, Littrell versus St. Thomas Wind Resort. Yeah.
We're,
Meeting with the client, but he's coming over with that.
we'll be right with you.
Thank you.
Now, your case is the only case. Is there any other case? What do you guys here on?
With, Chris.
Okay, all right, got you. And,
Yeah.
okay,
Judge, seemed like you had some confidential information. Do you want me to step out?
no, we're gonna handle your thing before we go on their thing. You don't know either parties anyway, so I don't.
No, you're on.
Where's that? The literal case here on the docket, I'm gonna find that pad. Yeah.
Sure.
I don't see it.
What's that?
Okay.
I don't have it now.
No.
Get it filed.
Sorry.
Okay, we have 18 CI 00129 McGraw versus Parks. Is that right? No, I got that. Oh, yes, that on the other case. Yeah, I got it right over here, right here. I got it. Littrell versus Thomas Land Resort. I don't have it. I looked over all the motions and I don't have it in your book. That doesn't mean you didn't file it. It's a motion to dismiss for lack of prosecution. What do you have to say, Mr.
I checked the time, I got this Monday, and I just presumed it was next motion day.
It was electronically filed by he got it for the e-filing system. I sent him a writing, sent him a backup copy on He responded, I was saying, on. I never heard anything. I filed it on Friday, the court from. Well, and it was E-file. And that may be correct, Your Honor, but it didn't get out. Somehow, we review our dockets in advance, but it wasn't all in the docket. So, I didn't look at the notice because when I got it belatedly that way, I thought, well,
Well, what it was on the docket, correct?
here's the picture.
Wait, I'm not doubting that. I'm trying to find out why I don't have a copy of it in my book. It's an administrative thing, has nothing to do or with you.
It doesn't exact, Q3 at 8.7 AM.
2-3.
That's Monday morning, so I filed Friday.
Yeah, well,
They didn't enter Monday morning.
Yeah.
Made it a job.
yeah, well, my problem is I had a trial Monday in one county and another trial Tuesday and Wednesday, and then I've been here today. And then I've got a trial here tomorrow, which is unusually thing, and for some reason it slipped out. And Mr. Cross, why hasn't this case been pursued?
Because a lot of, Your Honor, if the court.
You get behind the microphone.
If the court recalls, counsel previously had a motion to dismiss. The court gave us a deadline about discovery. We furnished everything that we had. It goes back to loss of a witness, serious illness on the part of Mr. Trail. And
Well, what,
it drug too long.
can you defend this case now?
And
I mean, can you defend not having this case dismissed?
if I read the motion, I think I can. I mean, there's no reason not to go on with it.
Okay, well, the motion was served on you and you responded to it.
Right. I'm not talking.
I understand that. Okay. You want a second to read it?
It's a long motion. That's why I didn't.
How many page motion is?
I mean, I've got it right here.
You're pretty fast reader.
I know I am.
Yeah, I'll tell you what I'm gonna do.
My signature is on the top, the very top, it's 4 full pages. My signature is the top page 5. Judge, would you like to take a minute? Tell you what it's about.
I'd like to read the motion.
Let's let him read the motion for a second. I'll give you plenty of time.
Well, I glanced at it and.
We'll go back there in that room and read it now. Okay, now, you can see, if you want some privacy, you can go in chambers over here if you want, if you got other things that you want to do. And we're here in this case, and we won't leave here without knocking on the door. Okay. No. Find this case here. Yeah, one for Steve. Yeah, well, I'm. See, there, marked up. Okay, let's call McGaw versus Barber. Hear the respondent's motion for sole custody.